Hey guys, good morning. How is everybody today? I hope everybody's doing well. My name's Debbie. Welcome to my channel. We are on part 86 of the Phil Spector trial. Phil Spector was a music producer that murdered an actress named Lana Clarkson in 2003, and he went to trial in 2007. And the jury was hung. So it was a mistrial, and then they retried him again, and he went to prison. And Judy has trivia for us. At death, a few muscle contractions may occur, and the chest may heave as if to breathe. The Lazarus sign, or Lazarus reflex, is a reflex movement in brain dead or brain stem failure persons. Like the knee jerk reflex, the Lazarus sign is an example of a reflex and is involuntary. The reflex is often preceded by slight shivering motions of the person's arms or the appearance of goosebumps on the arms and torso. Hey, Terry. Hey, Judy. Yay. You know, it baffles me. Totally baffles me. Do you guys know who Lazarus was? Lazarus was Jesus's best friend. And he died. He was sick. And his sister sent someone to go get Jesus to heal him. Hey, Carla. Um, so his sister sent someone to get him, and he didn't go there right away. He waited. And by the time he got there, Lazarus was dead. And he raised Lazarus from the dead. His sister was mad at Jesus for not getting there before he died, but he got there and he raised him from the dead. So that's why that is called the Lazarus reflex. That is so cool. That is something I did not learn about in nursing school. And I love that it's named the Lazarus reflex. That is just so cool. I love it. I love it. That is so cool to me. I did something totally off topic, but I did something really cool last night. You guys have probably noticed, because I've been super hyper focused on this for a while. I am jonesing really bad to go to a theme park. um, so somebody, his first name is Tyler. It's the first time I've ever watched his channel, but he was live streaming from the Magic Kingdom last night at Walt Disney World. And I watched the fireworks live from Walt Disney World last night. I was like, yay! It was so cool. And he live streams every night from Walt Disney World. So, I don't know if I'm gonna watch him every night because it frustrates me because I want to ride the rides. I want to be there. I get frustrated. But it was really cool because in the past, like, I've not been to Disney World. I've been to a special event, but I haven't actually like been to Disney World, like an all-day Disney World thing, since 2008. And I used to go several times a year, every year. So I'm like, I need to go. I need to go. I'm having withdrawals to go. um. So yeah, it was cool. They didn't do like the what do they call them? Like the not lightning, the light overlay like displays on like on the castle. They did. It was so cool because like the what was the name of the fireworks show? Happily Ever After, I think. So like halfway through the fireworks show was like they did like red fireworks and the music got like ominous, so it was like the villain section of the fireworks. Hey Carla. And then they started playing the theme from Pirates, not the theme park Pirates of the Caribbean, but the movie Pirates theme. And the the guy that was live streaming it, he was at the very back of Main Street, so you could see because they put the light overlays on the buildings on Main Street, and then you've got the castle at the very end, and the castle looked like it was burning, and then they had the lights kind of on the buildings too, but the castle, because he was at the very end of Main Street, so you're looking down the street with the castle at the end, and the castle looked like it was on fire. It was the coolest thing ever. I was like, Travis, come here, come here, come here. And he missed it. It was so cool. And then when the song was over, like there was still lights so you could see, but like all the fiery overlay stuff stopped immediately, and it looked like it had been burnt. It was so cool. I was like, oh my god, I have got to go back to Disney World. I'm missing it so bad. So that was what I did last night. That was a lot of fun. I think I got a little bit recharged. I don't know what's going on with me right now, but I'm exhausted, y'all. I don't know why. I don't know what's going on, but I'm like, every morning, snooze, snooze, snooze. Every morning, I'm just like, I'm so tired. I don't know why. Um, I'm just, I don't know what's going on with me, y'all. I just really don't know. Other than I'm just exhausted. I might need another iron infusion. Might be time for another iron infusion because I am chronically anemic. So it could be time for another one. I have a follow up with my oncologist on the 15th. So, oh, yeah. Always wake up tired, but this is more than normal. This is like don't like the what day did I take off? Was it when I think it was Wednesday? Um I literally like I kept hitting the snooze button, and then I woke up long enough to just do a post for you guys to say that I would, we weren't going to have a live stream. I don't even know if I typed it correctly. I don't know if there were typos. I was just like awake for the 5 minutes or so it took me to type it. And then I put my phone down and rolled over, went right back to sleep and slept till, I don't know, 11, I think. Like I was so exhausted. I'm like, I don't even know if that was coherent what I wrote, but I just couldn't get out of bed. I just couldn't. I don't know I have no idea, but hopefully on the 15th they'll do labs and maybe they'll find something in my blood work that they can fit. Hopefully. This is when you have a chronic illness, it's really weird. It's like you want them to find something so they can fix it. but half the time, well, more than half the time, they can't find what's going on because chronic illness is just like, I'm going to do this to your body. I'm going to do that to your body. And no one's going to be able to find out what I'm doing. You're just going to suffer. That's basically how it goes with fibromyalgia. It's just like, ha ha ha, we're going to do this today. So you just have to, you have to deal with it and roll with the punches. And that's just your life. um, and fibromyalgia is like, good news. It's not fatal. Bad news. It's not fatal. So, oh shoot. I forgot to pull up Court TV. Yes, it is, Carla. Absolutely, it is. It's awful. I was hoping, because Travis is off Saturday, and I was hoping that we could go somewhere, and I thought maybe if we could just go somewhere, I might be able to get like a little bit recharged. Just go somewhere and have some fun. But every time I try to find out, because this is the rainy season, I do not know who named Florida the Sunshine State. Because in the summer, it's not. It rains every day. Every day. And it doesn't necessarily last that long, but when you paid over $100 to go to a theme park and there's a lot of outdoor rides and it's thundering and lightning and they shut everything down, you've wasted it doesn't last long, but if it lasts a half hour or an hour and you're stuck inside of a building just waiting for the rain to stop, you don't want to do that at a theme park. Although, if it's not thundering and lightning and it's just rain, that's the best time to be at a theme park. Because people don't stand in line that are out in the rain. I have walked on so many rides when it's raining because people don't want to stand in line. I was like, okay, well, I'll just walk right on the ride then. Bye. Love you.
Honorable Larry Paul Phillips, presiding.
All right, defendant's present with his counsel, the district attorneys are present, the jurors and the alternates are not. Before we call out witnesses this afternoon, there are some matters we have to do with the jury. I'll comment on the talking to the defense and the prosecution and I want to be able to tell the jurors this as far as scheduling. As I understand it, you have one major witness, I'll call him
Stop.
major witness, that's Dr. Bodden that you're going to call probably on Monday. Yes. You're going to recall Mr.
PEX, yes.
And then you have some other
Yes, that's correct.
witnesses that are going to deal with computer records.
Custodian of records and or computer records, or like one of them deals with the ASCLD records from the Sheriff's Department, but basically records, witnesses that
Custodian records, witnesses will be very short.
Okay, and then
Just foundation.
You'll be prepared.
This is
for
our case in chief.
your case in chief. I know where we're at. It's hard to keep track of, but I know where we're at.
You've got the detailed report.
Okay. Once you rest your case, the people will call, I know of one witness, Ms. Robitaille, that you're going to call in rebuttal.
Correct, and we're considering calling a neuropathologist, but that decision has yet to be made.
Okay, and then whatever, sir, rebuttal, depending, I guess, somewhat on their decision. So we should finish testimony next week,
I can't imagine we wouldn't.
absent some surprises.
We have to decide on the Bennett thing.
Oh, I'm prepared. We can do that on Monday, but unless if you have anything new you want to add to that.
No, but I just wanted you to, understand that was still on the table.
I understand that.
Whatever you decide is fine.
Okay. I want to be able to tell the jurors that the issue we'll then have to deal with, and no way to know right now, and I know the jurors have inquired, and I don't have any problem discussing it in general terms with them. We would normally then probably spend 1 or 2 days going over jury instructions. It depends. It can't take more than that. It's just a matter if it takes less. It could be much shorter than that. We would be prepared to move forward to final argument, and then we have the issue of Ms. Kinney-Bott. Now, I understand from what you've told me without getting into any amount of great detail, she is suffering from some kind of serious virus that is yet not fully diagnosed.
You're correct, yes.
And her availability for argument at this time is unknown, and at what time is unknown.
Correct.
Okay. When do you think you might have some further medical information?
I will have medical information for you tomorrow.
Okay.
I'll have, but I don't think that's really the question you're asking.
Well, I'm trying to sort of, when will we have hopefully a prognosis? And obviously, we all want it to be that you will be able to return in a reasonable time to argue part of the case.
Right. Of course, we all want her back, and I think we all are on the same page in that regard. I would guess that we will have a definitive answer on that by next week.
Okay.
And the only reason I can't do any better than saying next week as opposed to a particular day is because I am ferry her to the doctor tomorrow.
I know the doctor wants to see her again on Monday for further testing. I think after that I'll be in a position where I can inform Mr. Jackson, Mr. Dixon, as well as yourself as to where we are. Because obviously, as you know, the doctor is my doctor, so I'll speak with him. I'll try and get it pinpoint as much as I can, and of course, depending on how she feels. So I think by next week.
Okay. The reason it's so important in timing is if there's a reasonable prognosis that she can be back in a reasonable amount of time, we'll have to look at what that time is as to whether to defer argument to that date. If, unfortunately, she's not going to be able to return either at all or in a reasonable amount of time, then we have to move forward from that. I've had informal discussions with counsel indicating what I think the law is in that regard, but I'm going to wait until we reach that point before we have to discuss it further. I'm going to talk, first of all, I know the press was present outside Mr. Spector's home, obviously with the exception of Ms. Deutsch, who was inside and was able to go everywhere that the jurors went. She had full access, the same as the jurors did, and I believe was able to report back to the media on that. But that's led to some other issues that I want to talk about. Let me, first of all, I think it's important. A jury view is never an easy thing, and this one took a lot of planning, and I think that we have to thank Sergeant Wheatcroft and Deputy Koblenz and all of the people from the Judicial Services Unit of the Los Angeles County Sheriff's Department. They did a terrific job, and also the Alhambra PD for their help and assistance in dealing with the streets and other matters. It really went very smoothly and very quickly, at least in my estimation, and I've done these before. So I want to make sure those individuals are thanked. There are some issues during the jury view. I gave the jurors an opportunity to get together, and after they all went through the view, to go ahead and see if they had any things that they wanted to see that for some reason they hadn't been able to, and then counsel and I discussed whether it was appropriate. They gave us a list of 10 things. I wrote on it are some notes that I made in answering their questions and discussing it with counsel. Some they were allowed, some they were not. The list will be filed along with my handwritten notes because I hadn't considered it at the time, but we'll go ahead and file that And that's what happened as far as that goes. Now, there is another issue that we have to deal with. I'm probably going to regret getting into this, but I really do feel an obligation to do so. Because if it's what I believe and I think it's appropriate, I have made sure in this case, as I try to do in all my cases, that the press have the widest access that they could possibly have within legal bounds to this trial. I'm a firm believer in complete openness and transparency in covering a case. I think it's important. And I try to do, and my staff tries to do all they can to assist the press in that regards and to allow cameras into the courtroom, which we have done. Something happened that I am not very happy about, and I feel the need to just go on the record as to what happened and how it happened, and then I'm going to go past that. After I made my ruling the other day that the press would be allowed one pool reporter to accompany us to the jury view, and I want to go by this bit by bit because I think it's very important. Before I made that ruling, I briefly discussed it with counsel. There had been briefs filed on behalf of the media, which I read and considered, and then taking a look at the law, very little of which was directly applicable to our situation. I ruled that it was appropriate because I believe it's important to have the press present when we do anything, as long as it's legally allowed, that at least one member of the press be able to accompany us on the jury view to watch what we did and how it was done, and that was done. At the time when I made my ruling, Mr. Rosen opined that Linda Deutsch would be a good choice. I think the people said that's fine with them, and since I've known Ms. Deutsch for some 30-some years, I agreed to that. We said the press will pick the reporter, and that was left up to them because I don't believe it's appropriate for the court or the attorneys or anyone else to tell the press which member will accompany them. And this is where this problem arose. My understanding is what happened after that, and I get this information through our public information officer, obviously I wasn't there, is the press had a meeting. There probably was not great joy that I only allowed one reporter, but that's the way it goes. I had to balance property rights of Mr. Spector against the rights of the press and the rights of the public, and I did so in the way that I thought was legally appropriate, by allowing one person on the property. And I understand the press wasn't too happy with that, and that's fine. We don't have to agree with those things. And at that meeting, and I understand it was perhaps by secret ballot, but whatever, Ms. Deutsch was selected as the representative. That was the press's decision who to select. Mr. Perricchini reported to me that could I perhaps reconsider my ruling? Could there be more than one reporter, especially the Times is the largest newspaper in the Los Angeles area, and they would like to have a reporter present. What I told Mr. Perricchini was my ruling stood, but this is where no good deed goes unpunished, and that's exactly what happened, that I would ask the defense if they had any objection to perhaps one or two further reporters to go along. I didn't have any problem with it. At the time, I didn't foresee a problem, but I would ask, and that's all it was. I had already made my ruling. The ruling was done. I passed it along to the lawyers the other day. The defense did not wish to go along with that. The reasons are unimportant, although they did indicate their reasons for doing so. It made no difference. Once they said no, they're not making the decision. The ruling had already been made. I voluntarily said, do you want to modify my ruling? Do you have a problem? Yes. That's the end of the story. Well, apparently, because of the reasons given, this didn't sit well with at least certain members of the press, and up to that point, we're still fine. But because of the reasons given, apparently, at least one member of the press confronted Mr. Rosen yesterday, said some rude remarks to him, and I think that's inappropriate. That is not the way, in my mind, that these matters should proceed. I do not want the attorneys in this case to have to worry about confrontations outside the courtroom with reporters. It's inappropriate. That's my view. My concern is getting this case tried and getting it to the jury, and I don't need any unnecessary distractions. If you're happy with my ruling, fine. If you're not happy with my ruling, fine. The decision was mine and mine alone. There has been some speculation that somehow Mr. Spector's wishes influenced my ruling. The ruling had already been made. As I say, I tried to do somebody a favor, and this is what we get for it. So keep that in mind. I'm just going to leave it there. I'm going to move along. I hope if anybody else wants to say anything, that's fine. If not, we move forward. Mr. Rosen, do you want to say anything?
I don't think so, Your Honor.
Okay.
The court's covered it well.
People were clear? Okay. we will move forward. Now, at the scene, one thing I want to do with the jurors before they go home, juror number 4, when he was at the scene, he came up immediately to one of the bailiffs, I believe one of the security personnel, this deputy sheriff who was there, he thought he recognized. So we will do what we do every time there is an incident when a juror, and they've been great about it, reports to us that they think they may have seen something that may be a problem. I will make the inquiry of whether, having seen someone he recognizes, he thinks that's a problem. I believe I know what the answer will be, but you never know, so we'll make that inquiry, and if anybody wants to follow up with that, that's fine as well. Do we have anything else we need to do with the jury, or frankly, that we need to do today?
We thought since they're here and we're all here, Mr. Plord and I or Mr. Rosen and I could agree on a stipulation that deals with the lease for
Okay.
Ms. Clarkson. That's a simple matter, and I'll just read the stipulation in and mark one piece of documentation.
There's also a legal issue that has arisen this morning that will need some time, but not with the jury.
Okay, that's fine. Just trying to think. Oh, there was, Mr. Rosen, there were some things you wanted to make sure that the jurors understood about the scene. I'm trying to remember. I said to go ahead and make the record.
I was going to wait. It had to do with the fact that the radio, or the stereo, was playing at the time that entry was made that morning. And our position is that should have been played at the scene. I requested that. The court turned me down on that. I wanted to make a record that because of what I observed at the scene regarding how certain jurors paid particular attention to certain portions of the location and things that may or may not have been important to some and not to others. But I think one of the issues in this case certainly will be, in closing arguments, to address the question of audibility at the location. And so what we're going to ask is this: since this review has taken place and we're now on the other side of that, the defense is going to ask the court to inform the jurors today that at the time that entry was made that morning, the stereo was in fact playing, but we were unable to play it today because we were unable to determine the volume, how high the volume was, how moderate it was, or how low it was. But at that time, music was playing, and that would be in lieu of the request that we made to the court.
Okay, I'll hear from the people now.
A different take. Testimony in the record is that when entry by the Alhambra Police Department, and that was 40 minutes or so after the initial call, 911 call. At that time, when Detective Tomlin arrived, there was some music going on, but we have no testimony as to what was going on at the time of the entry by Alhambra. I don't believe we do, nor at the time that the shooting took place. And so I think what Mr. Rosen suggests would be inappropriate, because we just don't know. I mean, what we were trying to do is talk about what happened at the time of the shooting, and then Mr. D'Souza making his comments to the defendant. We don't know what was going on there or what level was going on. It's calling really for a lot of speculation.
Okay.
Our understanding is that nobody knew how to turn the music off, and it was on actually when people arrived after it was turned over to the defense team the following evening. So maybe we're in a position where we just have to evidence that, but I think it would be the level is really the concern. Does anybody remember the level and so forth?
Yeah, the point I think that's important is just so they can factor in the facts that at that time there was music playing, what weight they decide to assign to it, because it is in evidence. I think it was Detective Lowenfeld. I could be wrong on this, but my recollection is that he did indicate it was on. And obviously, there's been no testimony that any of the law enforcement personnel that were there that morning flipped it on or turned it on. And as I understand it, and I remember, I think Mr. Plord is correct in his recollection, that in fact they were unable to turn it off. They couldn't turn it off, and it kept going on, even to the point where when Mr. Shapiro and the other members of the defense team at that time entered the residence on the following day, and I think the evidence is sometime around 5 in the afternoon, it was still on. So, again, we can't address the volume of it, just the fact that it was on is something that we feel is important to factor in, because otherwise it could be very misleading in the sense that they're there, they don't hear the music being played, which of course could contribute to the possibility of not understanding, maybe understanding who knows? But it certainly would camouflage some of the discussions which have been addressed by witnesses in this case. So that's all we're asking for.
Well, my feeling is, thank you, is that if you want to get into evidence, that when the detectives went out there, the radio was on, you get that if you don't have it in testimony, and I don't know whether or not Detective Lillianfield or anybody else testified to that, you call Detective Tomlin or whoever else you want in your case before you rest and get the evidence in that when they arrived, the radio was on. It's inappropriate for me to take any other notice of it or to do anything. One of the things that the jurors were not allowed, and I'll go over some of the things, after they finished their view, some of the jurors wanted to sit in the chair that has now replaced the chair that Ms. Clarkson was in. They were allowed to do that. There was a window that was open that I believe they wanted closed or vice versa that was at the top of the landing. Some of the jurors wanted to get into the car, and we no longer have the Mercedes. That's either been traded in or sold. That was the car in question on the night Ms. Clarkson died. The sheriff's got one of their plainclothes cars that they positioned in pretty much the space where Mr. D'Souza recreated the incident, which was testified to in photograph. They wanted to get into the car, turn on the air conditioning, the radio. That was not allowed because we don't know what the volume was. We don't know what the air conditioning was, whether it's the same in air conditioning units. Some are quiet, some are noisy. It depends upon the car and the make, and we didn't have the same make car. So that request was denied. They wanted to close the door and have conversations to see what could be heard. We don't know how loud the voices were, so we didn't allow that because we wouldn't have had the same situation. There was another incident where they wanted to do something I can't remember along the same lines, testing volume, which we can't recreate. And I view this, I can't, turn on a radio or not turn on a radio where we don't know what the volume was. But if you want to get to the fact that at the time certain people were there, the radio was on, the way to do that is call witnesses. So that's my view as to that. It's certainly appropriate for you to do so, but do it that way would be the best way. I don't know that we have, is there any other issues we need to deal with?
I think that's it.
After we get through with the jurors, I'm talking. Okay.
I almost forgot.
I know, you won't. All right. We ready for the jurors?
Yes, sir.
I'll do juror number 4 with the other jurors. I think that can probably move pretty quickly, and given the nature, we'll do it with all the jurors in the box. All right, the record will reflect that the jurors and alternates, all 18 of them are present, which means we had a successful field trip to the extent that we lost no jurors, which is good. I have a lot of paperwork I have to fill out if any of you turn up missing. It's hardly worth the effort. Just kidding. Just kidding. I've struck a mortal blow. Okay. Just one thing. Juror number 4, when you were at the scene, it's my understanding you thought you might have recognized one of the sheriff's personnel that was there? Yes. Does that... married to a cousin. Okay, so it's a cousin-in-law. Will that cause you any problems? And I want you to tell us, do you think it might cause you to favor one side or the other?
Not at all. I haven't seen him in a long time.
Okay. Based on that, does anybody want to make any further inquiry?
I just want to know if the wedding was nice.
Okay. It doesn't sound like it'll be much of a problem. I know that Wendy has briefly discussed with you some scheduling. I just want to go over what I know and to give you a heads up and so you can make some plans. It looks like we will finish. We are not going to have any testimony this afternoon. The defense will complete its case early next week. There will be some rebuttal from the people. There may be some further rebuttal from the defense. It all depends on who testifies. But right now, we believe that the testimony will conclude next week. Now, after that, the court will take a day or two. This is where it gets somewhat murky. We would take a day or two to go over jury instructions. You won't be present when we're doing that, so you'll have some time off the week.
Belle is whimpering and barking. I have no idea why. She heard her name when she came back over here. Yes, I'm talking about you. Shadow has the zoomies. She is chair surfing. And every time I walk by the chair, she gets down in the seat and she looks up and she flattens her ears down and her eyes get really big. And when I walk by, she reaches up and tags me. And Spike is just laying under the table being a good boy. It's the girls today. I'm gonna lose it, y'all.
week after that. Normally, we would go directly to final argument, which would probably take about 2 days to complete. However, as you are well aware, Ms. Kenny Bodden hasn't been present. She is suffering from some undiagnosed virus. She is on doctor's orders in bed. She, at this point, is not ready to come back to the case, and we will have to see what the prognosis is, which we hope to learn next week, which then factors in as to when argument will begin. Normally, it would begin right after jury instructions, but it may not. I don't know. I have to find out if she's coming back, and if she's coming back, what the estimate of time is, and that will lead me to some other decisions I have to make that right now I'm not prepared to confront because they're not in front of me, as to how much time the defense may need to prepare and some other matters. So frankly, we don't know what's going to happen at this point. I'll know more next week, and as soon as I know, you'll know. I know that some of you had indicated sort of a...
Yeah, but when she chair serves and scares the crap out of me, because from here, it looks like chairs are just moving on their own. I don't see her. I just see chairs moving behind me. No one in them.
a preference to take some time off because we're now coming up, I believe, next week. At the end of next week, we will have arrived at the 4-month mark, which is what we told you was sort of the outside. But if you factor in the fact that Mr. Cutler was sick for a while, I know some of you have indicated children are home from school, and before they go back from summer vacation, you'd like to spend some time with them. Originally, I was going to say no, although I've given you pretty much everything else you've asked for. Sometimes you do have to say no. It may be now that we'll be able to do that. I don't know. I'm going to just sort of give you, these are all possibilities. I'll know more next week. And when I know, you'll know. With that in mind, I think we have a stipulation, however, the council are prepared to enter into.
Yes, Your Honor.
All right.
Just a bit of housekeeping. I'll mark for People's next in order. People's 185, I believe.
You may be beyond that. Let me double check. Nope, you're right. 185 is your next exhibit.
People's 185 is a 8.5 by 11 document, front and back, purporting to be a rental agreement and or lease for the property of 3005 Grand Canal in Venice, signed on the date 9/23/99 for a rental agreement to begin on October 1st, 1999. And it'll be related to the following stipulation, and I'll address this to Mr. Plord. Mr. Plord, as Mr. Spector's representative, do you stipulate that Ms. Julie Jungwirth, and that last name, Cindy, is spelled Jungwirth, be deemed to have been called, duly sworn, and to have testified to the following facts? Number one, that she owned the property at 3005 Grand Canal, Venice, California, on February 3rd, 2003. That she was the landlord of Miss Lana Clarkson, and that she entered into the attached rental agreement or lease agreement for the above property with Miss Clarkson on October 1st, 1999. That this lease was in effect on a month-to-month basis on February 3rd, 2003. That during the course of this lease agreement between Miss Clarkson and Miss Jungwirth, Miss Clarkson was a responsible tenant who properly maintained the premises. That the terms of the lease expressed the owner's intention to sell or rebuild the property, and that if such intention were exercised after January of 2000, Ms. Clarkson would be given a 30-day notice to vacate. That there was a verbal agreement between the parties that due to the nature of the entertainment industry, Ms. Clarkson may from time to time be late with rent payments. That Ms. Clarkson was responsible for communicating to the landlord about any late payment, and that Ms. Clarkson always paid the $50 late fee. That at the time of the death of Ms. Clarkson on February 3rd, 2003, she only owed $130 in rent and late fees to the landlord, Ms. Jungwirth, and had communicated by letter about her intention to make payment. And finally, that at no time during the tenancy of Ms. Clarkson did Ms. Jungwirth or any agent of Ms. Jungwirth ever issue an eviction notice or threaten Ms. Clarkson with eviction pursuant to the terms of the lease.
Agreed.
So stipulated, and ladies and gentlemen, that stipulation is accepted by both sides, and it is now before you as a proven fact, and you will accept that as a fact that has been proven to you. Anything else before the jurors are
Not
released?
for the people, Your Honor.
All right, ladies and gentlemen, thank you very much. Keep in mind the admonition, and we will see you 9:30 on Monday morning. Thank you very much. All right, the jurors and the alternates have left. You said you had a legal issue?
Yes, Your Honor. Basically, what I'm going to lead up to, what this will lead up to is I'm going to ask the court to order that we conduct a conditional examination on Monday afternoon. I have a witness, Mr. Mark Hirschfield, who's a executive for ABC, who's in town as of this morning, but is leaving Wednesday and is unavailable Tuesday. His testimony is very critical to an issue that arose yesterday and that I just was able to get the information on this morning. I need to make a written application. I can make a generalized offer of proof at this point, and then since there's a requirement of 3 days notice, go back to my office and prepare a declaration and send it in this afternoon, so I can tell you on the record what...
Why don't you tell me where you're going and we'll see what happens.
All right. Yesterday I received a letter purportedly written to Lana Clarkson by Mark Hirschfield. The letter was extolling that videotape, what a great actress she was, and so forth. There were some anomalies in the letter, and I don't know if you recall, I was running in and out of the courtroom yesterday afternoon. I was able to reach Mr. Hirschfeld in New York. I read him the letter. He said, I didn't write that letter, but he wanted to see the letter to be sure. I faxed it over to his office. He reviewed it this morning. It's not on his letterhead. It has several factual errors. For example, Ms. Clarkson purportedly, the letter purportedly said that Mr. Hirschfeld was responsible for casting Ms. Clarkson into a play or into a series, Three's Company. He said he never cast her and that he had nothing to do with the casting of that particular play. There were mistakes in attributions of titles. It was filled with errors. The signature wasn't his. The title beneath the signature, his purported title, was not correct. I asked him when he would be available to testify, and my understanding was we were going to do Deborah Robitaille today and perhaps Donna Clarkson, who was the conduit that these letters, this letter and a couple other similarly suspicious letters were provided to us, would be testifying this afternoon. So I caused a subpoena to be issued to him for appearance here Monday afternoon. In the meantime, the schedule changed, and so he won't be back once he leaves on the 15th until the 25th, and it appears that it's highly likely we'll be done by then. So I therefore am requesting to have the court designate itself a magistrate and conduct this conditional examination. My direct examination won't take much longer than what I've just taken to describe.
Can I ask, why is this a conditional exam? I guess perhaps there's something I'm overlooking.
At this moment, the prosecution hasn't offered the letters, and I believe that they're not going to offer them. Well, I would be very surprised now that I've revealed what I found out, that they would offer them. And so in the natural order of proof, we won't get to him until, well, theoretically we could put him on Monday afternoon, but we have to, they have to finish their case, we have to finish our case, and this would really have been a sure rebuttal. It now looks like we could put Miss Donna Clarkson on to establish that these letters came from her daughter, that they were purported by her daughter to be real, and that she passed them on to the people, believing them to be real. And I think the court had indicated that they seem to be probative on state of mind of Ms. Clarkson. So, I mean, if we can call those people out of order and put them on, we can do that. It doesn't have to be a conditional examination. However, if we can't, then I need to preserve his testimony.
Now I understand.
Gary, could we have the 3 letters marked as an exhibit?
Sure.
We gave them to the court. We got them from the people on Monday.
All right, your next exhibit would be, we'll mark them collectively as F11, 3 pages, 3 letters collectively, F11.
And you have those in your possession?
I do, and I'll mark them. All right, let me hear from the people.
Your Honor, I guess the first point, the first hurdle to get past before we start getting into conditional examinations and Donna Clarkson, et cetera, is the kind of the last point that Mr. Brunon made, that this is relevant to Lana Clarkson's state of mind.
No, I think what he was saying, and if I misunderstood, please let me know, that if you put in these letters to show that Ms. Clarkson, was upbeat, she was felt good about the tape, that, she could look forward to work, they're now prepared to put in evidence that says she knew that's not true because the letters weren't true and she knew they weren't true.
Right, and that's the if. We're not putting the letters in.
Okay, you're making
we have no intention to, so unless we put the letters in or put the letters on, that's when it would become relevant, I would agree. But
Okay.
we're not introducing the letters, we're not going to seek to introduce the letters, so it's not relevant.
Okay.
Your Honor, we were just advised by Mr. Ocampo that they may not put on these letters just a few moments.
Well, now you have an
Now we
absolute.
have it on the record, which is very consistent, and something was said that they've apparently done some investigation to determine maybe the letters weren't what they purported to be. That's exactly what we were finding out, too.
Yeah.
Consistency in that regard. We're asking for that information, and they promised to give it to us. They're just finding out, just like we are.
Okay.
But we feel that the letters now have an affirmative proof
Okay.
regarding issues, even if they don't put them on.
So then call your witness, and it's not a conditional exam, you just call them as part of your.
Okay, we'll just put them on out of order, and we'll do it on Monday afternoon, even
I mean, then
if
if, we'll have whatever objections, if any are made, as to whether it shows anything or shows state of mind or whatnot, and I'll rule on it.
Your Honor, I was going to ask the court to order Miss Donna Clarkson to come back to court on Monday, but I think this is the first session they've missed.
Well, I think that people can get her for you if you want.
Sure.
That's not going to be a
it
problem.
was represented that she gave those to one of the members of the DA's office on Monday, they immediately gave them to us.
In any event, since it's now no longer an issue of a conditional exam, he's going to be in town, you call him as a witness, and we'll take it from there.
I'll have him here Monday.
Okay, Wendy, we'll mark
And
this.
and obviously this is with the understanding that there's still a lot of legal hurdles that I think have to be. You're just talking about procedurally get the witnesses here, but
That's all I'm dealing with.
okay.
There was a time constraint because of the requirements for a conditional exam, and now those no longer exist, so it's not a problem.
Yeah, but we didn't want, this witness travels a lot.
He's not going to travel for, the bottom line is we'll deal with it when he's in town, and he'll either testify or he won't.
He'll be here Monday afternoon.
Okay?
Your Honor, yesterday you asked us to give a complete list of all our case in chief witnesses, and then the
Right.
people were to do the same, and we've been given, except for the pathologist, we just want to know if there's any other witnesses that we haven't been told about, just so we can get our planning done. And okay,
Mr. Jackson has indicated no.
very good.
So everybody,
a shake of the head.
everything is on the table.
Okay.
Subject to change.
How well said.
As long as we're here, if you want to deal with the Bennett issue, I'm prepared to deal. Let me tell you where we're at, because you may have a better memory than I do, and there may be other statements that I haven't factored in. The people wanted to introduce statements of pumpkin pie, Miss Pie, Ms. Lawfridge. I have a tough time with this. That she made to Investigator Bennett that were alleged to be consistent.
Excuse me, Your Honor, you said the people, the defense.
The defense wants to bring in, sorry if I said the people. During her testimony, it was brought out by her testimony that when she was initially interviewed by the police, she never said anything about Ms. Clarkson being depressed or having any problems. Then at some point, that changed. She spoke to, and she was initially interviewed in 2003. She then was interviewed, I think, Mr. Bennett, you told me it was 2005?
April 2005.
Okay.
Or May 2005.
All right. And then you wanted to get that statement where she talks about the depression and as a prior consistent statement.
There's two parts.
Go ahead, I'm sorry.
No, it's okay. There's two parts.
Okay.
The first part is the quote in the Bennett report, the quote of Ms. Laughlin regarding what Lana Clarkson said to her after she indicated in her testimony that she had been dissed. I don't know how you do that. by Michael Bay at the Franklin party. The other part of it is on the next page of the Bennett report. There is a small paragraph with information related by Ms. Laughlin to Mr. Bennett regarding the phone call that she had with Ms. Clarkson. I think you have the report which I provided you. I think it was within 3 days or 2 days of her demise. So it's two parts. It's the phone call within a few days, and it's the quote by Ms. Clarkson to Ms. Laughlin, which is related to Mr. Bennett in the April or May 05 interview.
Okay, well, and you want to get those in as prior consistent statements.
They're either prior consistent or prior inconsistent, but I believe they're prior consistent. That's what
Okay, well, let's look at Evidence Code Section 791 and 1236 to see whether they qualify. There's two sections, two parts to 791, and 1236 just references 791. Evidence of the statement made by him or her that is inconsistent with any part of his or her testimony at the hearing has been admitted for the purpose of attacking his credibility. Well, we know that that's been done. Certainly the people attacked her credibility. And the statement was made before the alleged inconsistent statement. Well, that didn't happen. The alleged inconsistent statement was her original interview in 2003, which she was confronted with. You never told anybody that. So the statement to be before that would have had to have been prior to 2003. It's not. So it doesn't qualify under Category A. Then you have Category B. An express or implied charge has been made that his or her, I'm obviously paraphrasing, testimony at the hearing is recently fabricated or is influenced by bias or other improper motive, which I agree that that part of that section has been established. Clearly the people attacked her credibility, both impliedly and expressly, and alleged bias and other improper motives. But the latter part of Section B, and the statement was made before the bias, motive for fabrication or other improper motive is alleged to have arisen. And the question, as I remember the testimony and the people's cross-examination, that basically prior to the statement to Bennett was not made before the bias. I think, as I remember the cross, that the bias arose shortly thereafter. The family, she was on the outs with the family. She felt marginalized, I believe was the actual testimony. And that's when it all arose. That's when so clearly all these statements are not before, they're afterwards, so they don't qualify as prior.
But Judge, you're making a factual determination of what the bias is and when it arose.
Well, that's what but the bottom line is it requires me to look at what the possible biases and motives are. That's what I'm required to do by the section.
No, I understand that, but I think that is a threshold level, that once the threshold is reached, I mean, the question is, could the bias have arisen then? Could it have arisen over time as she testified when the urgency or the urge to have the truth come out, is that when the bias arose? Or is there some other reason that she has a bias toward one side or another? I mean, this is something that it seems to me that the jury should get all of these facts and then be instructed in an instruction similar to the foundational facts under 1235 and 1236. Let them make a decision whether or not she was biased.
That doesn't appear to me to be the law. I think it's my obligation. These are foundational facts that I have to make before the testimony gets to the jury.
Well,
if you have something that says that this should be the basis of a jury instruction as opposed to my requirement, that's when you said it seems that you're making a finding. The code section requires me to make a finding.
I understand that, but it's certainly a preliminary finding that there is at least a colorable issue there. But the fact is that she made this statement to Mr. Bennett long before she ever was contacted and made a statement to the defense. So, but the jury doesn't know that at this point. The jury doesn't know that she made that statement that's consistent with her testimony before she was contacted by our investigators, at least in a meaningful way. And so now the both implied and express accusation that only after the defense contacted her and she decided she had this improper bias the other way. At that point, she made the statement that was consistent with her trial testimony. It just strikes me that given the amount of evidence that's questionable as to its foundation, let's just say that, but it's been offered by both sides. I'm not saying that it's predominantly one side or another, that this little set of facts ought to be considered by them as well.
Okay. Yes, go ahead, Mr. Wilson.
Just for the record, as the court knows, I spent a lot of hours going through
Right.
Ms. Laughlin's testimony. I'd like to just put in the record those citations that we are basing, at least in part, our argument. Just so the court will know where,
Yes, of course.
if this ever gets looked at by,
You know what? I can probably do it quicker than you can.
go for it.
Pages 73, 78, line 19 through 73, 81, line 14, 73, 81, line 27 through 73, 82, line 16, 73, 87, line 19 through 73, 88, line 18? 15. 73, 89, line 4, 74, 69, line 3, lines 3 through 13, and 7503, line 5 through 7506 through line 20.
I gave you my best handwriting.
Thank you. Those are the lines. People wish to be heard, because
Your Honor, we've discussed this before. Our position is the same, that these statements by Detective Bennett, or by Pumpkin Pie to Detective Bennett, have to precede the statement to Detective Tomlin to be a prior consistent statement, or as the court pointed out, precede the motive that Pumpkin Pie testified about the family that was happened shortly after Ms. Clarkson's death. So I just don't think it meets the evidence code requirements, and I do think the court has the obligation to make these foundational determinations.
Okay, I'll make a final ruling, sometime on Monday. I want to think about it tomorrow and over the weekend, but that's my preliminary ruling, and if something changes, I'll let you know.
May I just put a final
Yes.
footnote? I just want the court, and I'm sure since you've cited the pages in the transcript, you're familiar with it, but Ms. Pye never said that she developed a bias as a result of those. She said that didn't bother her.
Okay.
And
Yes, go ahead. I'll let everybody argue the second.
No, this is a mechanical.
Go ahead, then to Mr. Brennan's reply, Mr. Jackson wanted to say something.
Your Honor, what we're forgetting about is Mr. Brunon's argument is basically, you know what, let's just let the jurors figure it out. We can't.
Well, I've rejected that argument.
Good. I was going to say that the formal objection, obviously, is hearsay. This is rank hearsay, and there has to be a very specific, narrowly tailored exception to the hearsay rule, and 791 expresses that narrowly tailored exception. And unless the statement precedes, and I think Mr. Brunon may have stated the other day that the statement need only precede the testimony in court. That is clearly not what the case law says. That's not how the legislature intended it. The statement merely needs to precede the motive, or the date, or the possible date of when the motive is expressed, and she indicated that she did feel marginalized and slighted and ousted and exiled within the days and weeks following Lana Clarkson's murder, or it needs to precede the first statement, and it does neither of those. I mean, this is a very, very clear issue on hearsay grounds. It's not admissible.
Thank you. Okay.
this is a different issue.
No,
As soon as they're done.
Mr. Rosenby.
We all heard our 2 cents. I was just saying, if the court decides to permit it, then I would just ask of Mr. Jackson and Mr. Dixon that, I know that Mr. Bennett sometimes is not available. He's out and about, because when we had him in the hallway.
If I decide to admit it, we'll make him available.
Okay.
We'll find a way, or just stipulate to it. Okay, now, Mr. Port.
Yeah, I've given notice, since I'm doing all the, notice of witnesses and discovery to the people, I've given notice of at least a couple of sir rebuttal witnesses, which will come later on. But the two that I've given notice of are professionals, psychologists, psychiatrist type people that had contact with Ms. Clarkson. And I've notified Mr. Ocampo that we've discussed issues of maybe there's going to be a claim of some type of psychotherapist privilege. They haven't made that. I'm not sure who the holder of the privilege is. I believe it would be the estate of Ms. Clarkson, but there was some notion, is there a privilege? And we've debated that informally. My point is that if we're going to get into that, we should get the court involved, get some briefing done, so that we don't end up at the sir rebuttal stage with these witnesses, and then we get into this big brouhaha about privilege and so forth. And so I wanted to alert that to the court and see if there's really going to be a...
that this weekend goes the same as all the other ones before it?
Certainly, Your Honor. And so I don't know if there's really going to be a claim of privilege, but if there is, let's get it moving, and we'll decide. Then the court eventually decides it one way or the other, as the court does all the issues, and that way. But I don't want there to be a delay, especially when we're getting to the tail end.
No, okay.
Mr. Plord says it best, and I'd get hacking on the keyboard if I were Mr. Plord. There probably will will be a claim of privilege. I
Okay.
can, in my informal conversations with the family, would certainly suggest that. So if Mr. Plord is the proponent of the evidence, he needs to establish its relevance and that there is no privilege.
Can you give me at this point a very concise offer of proof as to who might testify as to what, so I can start to research the issue?
Yeah, I can. These are, one is a psychologist. I could give the name, but I prefer not to do
let's
that.
not do that.
Basically, a psychologist and I believe a psychiatrist. One of them is documented in her day planner where some type of therapy was done and the subjects were discussed, and that's in her day planner at certain pages and so forth. She's under subpoena. I'm not sure what her licensure is. She's some type of professional therapist. I want to say she's a psychiatrist, but I'm not sure. The other one is definitely a clinical psychologist that treats people for various things, including addictions and so forth. And we found out about her just recently because her name was mentioned in one of the new emails that we just received that came in this last wave of about
You know about that. If I was murdered, I know it would be helpful to talk to my therapist about things that might reveal who killed me. But I don't think I would want stuff about me getting out. Like things I've told my therapist, right? And there's HIPAA. And if you're dead, I mean, HIPAA still applies. HIPAA doesn't go away when you die. Like, how do they get away with subpoenaing? How do you say that? How do they get away with making people like medical professionals testify? Like, don't tell my deepest darkest secrets. That's, I don't care. Let them go free if you're gonna have to tell all my deepest darkest secrets. No. You know what I mean? Like, no. Don't tell all my deepest, darkest secrets just to convict the man that did it. Like, it's not worth, like Peter Trago says all the time, risk reward. It's not worth the risk. It's not worth the reward. It's like, no. I don't need, especially if I'm in Hollywood, who knows what I've done to get to where I am in Hollywood. You know what I'm saying? Like, no, I don't want my family knowing everything I've poured my heart out to my therapist or psychiatrist or whatever. Like, seriously, I don't think that's right. I just don't. I don't know how that is legal. I really don't.
Many thousands of emails or hundreds of pages of emails. So we contacted her, subpoenaed her to court next week. We've got her on call. We've got a report from her, very limited information because of this privilege issue, but we have information to the point where we know that there was contact between Lana Clarkson and this psychologist regarding, the type of work that she does. Basically, it's the psychotherapist type privilege. I forget the section number, but it's like if I go to you and I want to discuss my problems and you're a psychologist, that's the privilege.
You're welcome to come into chambers and discuss your problems. Let's just give notice to the people.
You do have that couch available, don't you?
Yeah. And anybody else out there, I'm available.
The doctor is in?
Yes.
In any event, Your Honor, that's what we're dealing with. I think that's pretty straightforward. I think the courts run into that issue once in a while.
That'll help me. I can get started.
Okay, very good.
Mr. Rosen.
Thank you, Your Honor.
Yes.
I have a couple of issues. In anticipation that we were going to see Ms. Robitaille this afternoon, I lost a lot of sleep last night and this morning, but that's part of the job in terms of preparing for her. In the course of preparing for her, there's two things that have come up and I addressed them informally, both with Mr. Jackson and Mr. Dixon. In part of the discovery, there is an area where she talks about, she's not able to identify the exact time, but she talks about the quote-unquote Kessel boys or the Kessel brothers. She going to her car, driving. She had somebody in the vehicle with her. She had a sports car, and she looks over, and depending which version you take, and there are some discrepancies in the versions, she either sees a pink Cadillac, which probably would be a very memorable thing to remember, or a black Cadillac, and she describes the two Kessel brothers being in them, one driving, and
I can shortcut this.
Please do. Not
A very memorable thing to remember. Really, Rosen? A very memorable thing to remember? Really?
that I mean to cut Mr. Rosen off, but go ahead.
I've talked with Ms. Robitaille. She told me this whole chase incident with the Kessel brothers. I won't elaborate anymore. And I told her it's really interesting talking about, but I don't think that it's admissible in court, and I'm not going to ask you that.
Thank you.
you're not paying that you didn't get to rule, are you?
No, it's okay. I'll suffer with it, but I'll get over it.
But the general subject of the Kessel brothers and their relationship to Mr. Spector is a different thing.
It was this particular. Okay.
This is different. And then the other was in terms of looking at the time frame on this, and I know the court's rule, this is, I guess you could say it's in the nature of at least a portion of requesting for reconsideration by the court on this. I anticipate, I don't know, I assume Mr. Dixon's going to present the direct on this, and if he is, there's really two areas that I believe he's going to delve into. There was an alleged incident that occurs in the 80s after Ms. Robitaille returns from spending 6, 7, 8 years back in the UK. She comes back here, and then she recontacts Mr. Spector. And I guess that one will have a direct and we'll have a cross, and we'll see where it comes out. But the other incident, which I really didn't focus on when both Mr. Brunon and myself argued about the admissibility of this long ago and far away when the court heard it and ruled that Ms. Robitaille would be allowed in under 1101B like the other witnesses, was this. The first incident, as best as I can glean from reading a number of different interviews, is that it occurred in the early 70s. And certainly from today, that's in excess of 35 years. And if we back it up 4 years to the year 2003, it's certainly at least having its third decade anniversary. So what I'm going to ask the court to do is to reconsider its ruling and limit the people to allowing them to put on the evidence of the alleged 1980s gun incident, but not to be allowed to put on the early 70s gun incident because it's just so remote in time. It really goes back even further than any of the other 1101Bs, which I think the earliest one, if I remember right, starts in 83 or 84, and it's at a time when, I mean, let's face it, as we go through life, we all become different people, and that was in a time when Mr. Spector was in his 30s, and he's now in his mid-60s, approaching 70. So I'm going to ask the court to revisit just that part of it. I'm not asking the court to exclude the 80s incident. The court's ruled, and I accept the ruling on that. But when I read it last night and into the early morning hours, and then this morning I got up early and read it again, it just struck me that it's really very, very remote in time. So,
Hey, Rosen, people that do this kind of stuff, they don't get better. They just get worse. They do it more as they age. They don't quit.
I'm going to ask the court to reconsider its ruling on just that portion.
Thank you.
Well, Your Honor, we did consider both these incidents and rule on them. It is about 6 years before the one that Mr. Rosen concedes. It matches almost identical to the early 80s incident. It was at a time when Ms. Robitaille was in the employment of the defendant. She was working for Warner Spector Records. Her relationship had evolved from employee to employee, a close friend, and then to a romantic relationship. It's what we've heard of so many times. She's at a party. Part of her responsibilities are to not only go to the party and kind of make sure everybody's there, play the piano a little bit, but also socialize and assist Mr. Spector. At the time they were having a romantic relationship, as she says in her English accent, I was the last man standing at the party. I asked to go. I said I wanted to go. The door was locked. The next thing I know, there's a gun gun pointed in my face, screaming and yelling, "You aren't going to go, I'm going to blow your blankety blank head off." Eventually, well, and she will say, and I'll be candid here, that she put on her very prim British demeanor and basically dressed the defendant up and down and kind of talked him out of pointing the gun at her. And after some period of time, she was allowed to leave. That's a very brief version of it off the top of my head. It matches very closely as to what happened in the early 80s. She, at some point, left his employment, returned to England, got involved in the music business, and then came back to Los Angeles and returned to his employment and was at a party, just like the one I just described, doing kind of the same sort of thing when she tried to leave, and the same thing happened to her, including the same kind of screaming and yelling at her with a gun pointed at her head.
Okay, thank you. Mr. Rosen?
And Mr. Dixon's words, which I want to borrow for a moment, precisely reinforces my point to the court. He just said a moment ago, the 70s incident, the early 70s incident matches very, very closely with the 80s incident. And that's exactly why they don't need it, because it is further remote in time, much further remote in time. It's not 6 or 7 years, it's even further than that. Because I think, depending which version you take, she's either gone to the UK 6 years, 7 years, or 8 years, and the 80s incident doesn't occur immediately, it occurs sometime after she returns. So by his own words, he says it matches very, very closely with the 80s incident.
You know, Judy, that is weird. Because, well, why did my laptop die? What is happening? Dang it, my laptop died. I saw that today on Court Vibes when I was in her channel, but it's not showing up that way on StreamYard. And what is my laptop doing? It just died. Why did my laptop take a dump on me? Shoot. Well, I have to pull up my channel on here. Hopefully it won't crash StreamYard. Let's see. Well, load. Nope. It's still... That's weird. That is weird. It's normal on my channel. Why is it normal on my channel and different on other people's? I mean, not that I care. Is it... weird? I wonder if it's maybe monetized channels? Because at Court Vibes, is Terry here? Yeah. See, Terry is Terry Ham. But in Court Vibes this morning, she was at just a main girl. I don't know what's going on. That's just... Okay. I don't know. I don't know what's happening.
And that's what I'm saying. I'm not quarreling about the 80s incident, but he gets in through the 80s incident exactly what he wants.
Okay, thank you. What I'm going to rule, I mean, I've already ruled your reconsider.
Yes.
Actually, again, and this has to do.
Yeah, in court vibes, everybody had an at in front of their name, but I think people whose at is different than their. Because, like, you have an at name and then you have what everybody sees. And Terry's is just a main girl, at just a main girl. But then it's Terry Ham. But on court vibes this morning, everybody, like mine was at WF Cook because my at is the same as my name. But Terry's, instead of being at Terry Ham, it was at just a main girl. But everybody had the at in front of their name. But it's not like that on mine. So I'm wondering if it's just a monetized channel thing. And now my laptop comes back on and then shuts right back off. I don't know what's happening. I rarely know what's happening though.
Do with all the 1101 or most of the 1101 or some of the 1101B witnesses. Instances that on their own, if they were the only instance or only incident,
Yes, it is, but I love your at name.
might be considered remote and might be excludable, especially under 352. But what I've found, and the reason I let these incidents in, the ones that directly related to use of a weapon with an individual, the pattern. And in this case, and it's where I'll disagree with you, the fact that it's old, which certainly it is in the 70s, it actually reinforces the people's argument. It shows a continuing pattern that now goes even longer. And the fact that it's old by itself, if it was the only incident, I might agree with you, but it's not, therefore it will come in. All right. If there's nothing else, I'll see you Monday at 9:30. Thank you.
Thank you.
Yeah, when you guys leave comments, I can see your at names. When you leave comments on my videos, like when you're replay crew or whatever. We have Mr. James Peck again, the blood spatter expert. If it, I know when I was looking for my channel a minute ago. Hi. Sorry about that. they don't notify anybody about anything. Like the stupid crown thing. I disabled that because I don't like it. It's distracting. And then this morning got on there and saw all the ats in front of the names. I'm like, good gravy Marie, why do they keep changing crap all the time? No, I was talking and then I noticed that StreamYard had crashed. So, the channel that I was telling you about when I first got on, some of you weren't here, Daily Fast Pass. The guy's name is Tyler. He live streams from Walt Disney World daily. So I watched the fireworks at the Magic Kingdom last night. He's in Epcot right now. So if you want to see Disney firsthand, like someone is there riding the rides and doing the things, and it's a nice guy.
Order, Department 106 of the Superior Court is now in session. The Honorable Judge Larry Paul Fitzgerald presiding.
Thank you. The defendant's present with his counsel. The district attorneys are present. The jurors and alternates are not.
Sure. Mr. Dixon and I have chatted about this. Your Honor, I have a witness that we've got on Goldenson, and the offer of proof on it is as follows, that we understand that within a few months period.
I was going to just give him the report.
That's fine.
We've got a report.
We'll hand it up to you. You don't have to listen to my words.
Yeah, and there's actually a report and email that was taken off Mrs. Clarkson's computer, and between the two of them, it tells the story of what's going on.
Okay, I've read the email as well as the report.
Yes, Your Honor, basically what it is that we're seeking to call Dr. Goldenson, and as you can see, for a very, very limited purpose. We don't intend to get into any privileged matters because there was no privileged matter. She never saw Dr. Goldenson. Dr. Goldenson never consulted her. Apparently what happened is the breakdown was that there had not been an approval of health insurance by SAG at that point, so therefore I've spoken with Dr. Goldenson, and she said that after they had this phone conversation, she never heard back from her again.
Are you saying the phone conversation is not privileged?
I don't believe it is, to make an appointment.
Well, there's more than just an appointment. There's some discussion there.
Well, yeah, I don't think that is.
It's the purpose for consulting her.
I understand. I understand. I don't think it is privileged. I don't think it is.
A client comes to you and says, I want to hire you.
Yes.
And says, I committed a robbery. How much do you charge? And you give them your very high fee. And
There's a lot of people like that.
And the client says...
You had to say that, huh?
The client says, I can't afford that. Thanks. I'll go...
I've never heard that.
I'll find somebody else. The conversation with you when they were in the process of hiring you, is it not privileged?
I think that would be privileged, yes.
Okay.
That hypothetical, I think, certainly would be, because at the most, it's a confession, at the least, it's an admission, so clearly it's privileged. The fact that they decide not to hire me for the reasons given, of course, the privilege still attaches, we know that.
Okay. Well, there's certain language that's contained in your report, which would be Ms. Clarkson saying something to this individual as to why she was talking to her, it seems to me would be privileged.
May I have one moment with Mr. Clark? I thought on this.
Okay.
I don't, it's a good one or bad. Your Honor.
Yes.
The reason I asked for a moment is just to kind of get this with it.
Well, there's
Donna
another
Clarkson is here to claim the privilege.
And we'll go from there. The privilege certainly goes beyond the death of the individual. If the person claiming the privilege is the appropriate one, we'll have to find that out. Okay. Go ahead. And then we still have the issue of the email, though, which is separate and apart from...
One argument we could make, Your Honor, is that the email, which clearly is not privileged,
A separate issue.
okay, in order to give meaning to that, you have to follow up with this statement. In other words, she said she intended to do something, and then did she follow up with her intent? It's circumstantial evidence that the email, and it corroborates the email. And the email itself suggests that she would be going to that person unless she wanted some help with something. So that example is waived. She's basically another person who clearly is not within the confines of the privileged relationship, that she's going to be going to this psychologist and so forth, and even gives the reason why she might be going. And the fact that she actually made contact corroborates that. And that's really not privileged. The fact that she made a phone call, dialed this person's number, had this person's phone number, is the inference can be drawn that she needed some help, that even without getting to her statements. So I believe that this is technically not privileged. It's already been, in effect, waived. We would also just take the position that privilege doesn't apply under these circumstances. In other words, is the privilege absolute or is it not absolute? There's arguments that I think could be made either way.
Well, I'm listening for the arguments.
That basically the waiver of the privilege by the email and other evidence that's been presented in this case.
What are the dates of the phone call compared to the date of the email? The email is January 2nd, 1904.
Well, we know the 1904 is incorrect. We know it's 2003.
We know it's within we believe it's within the 1 year window before she passed away, before Ms. Clarkson died, but we're not really
The time
sure.
we've been talking about, 2000.
And I believe that the doctor doesn't have a clear record as to when that date is, but she definitely remembers the contact being made, et cetera, and the reason for the contact being disengaged. And that's pretty much all she says. So
I would also just footnote part of Mr. Plort's argument by merely saying it is a separate issue regarding the email, and I agree, but also if the statement is read in conjunction with the email, it may very well be that Mr. Plort makes a good point that it may in fact not be privileged because it has been published here in the email in terms of a response here. So
we think we could still call her if the court rules that we can't get into the statement of I need your help type thing. In other words, the hearsay from Ms. Clarkson, then we should still be able to call her and say, was contact made? Yes. Did anything ever come of it? No.
The question is, was contact made? If I talk to you, the very fact that I had a conversation with you, even if you don't get into the conversation, I'm asking you, is that or is that not privileged?
our position is that it's not privileged.
Well, give me a case. Give me some law.
I think that there's a bright line distinction between actually contacting somebody. It'd be like, using the example you did with me, it's been my experience, in 37 years I've been doing this, where I will get calls. Mr. Rosen, I want to come in and speak to you. Can you set an appointment? Sure. I'll put the individual on to my secretary. My secretary will book the appointment, and I may never see the person. This has happened where they just never even show up. Some of them don't even give the courtesy of calling back to cancel the appointment. I don't think that's privileged.
Well, I'm asking you, if you'll give me some law,
Okay.
I will take a look at that, whether the contact itself is privileged. The conversation, I'm very comfortable at assuming that the person claiming the privilege is the appropriate.
Did he say 37 years? He's been doing this for 37 years? Has he been making the same bad jokes for 37 years? Jeez, man, you'd think you would have your jokes perfected by now.
Appropriate person, that you cannot use a privileged conversation and then say it is corroboration of another email. That argument doesn't work with me at all.
We'll take a look more on this and do help you out.
I don't know if we need to get to the privileged area at this point or not. We might be able to do it by stipulation. I don't know. Whether she's the person to claim the privilege.
Just whatever is our representation that she's authorized.
Well, it's not Mr. brought.
What's your offer of proof? I think that.
My offer of proof is that Donna Clarkson is the executive of the estate, and she has the privilege and would claim that she's here with her lawyer to do so.
Okay, maybe y'all want to talk with somebody and see if you
Yes.
can arrive at a stipulation.
Maybe we could do the break.
Right.
Mr. Dixon and I can chat about that, and maybe if it's the fact that we could probably work something else.
Okay, are we ready to go? Can we get the jurors out? You've previously been sworn to your under oath. Would you just state your name again for the record?
My name is James Pex. Pex.
Thank you. Would you take the stand, please? You may proceed.
Welcome back, Mr. After the time you've returned, we've gotten some records from the Los Angeles Sheriff and Crime Laboratory that weren't available to you when you first testified. Have you been provided with some additional records to that end?
Yes, I have.
Could you tell the jury what additional records that you've been provided?
I was given the ASCLAD lab inspection report dated March 21 of 2006 for the Los Angeles County Sheriff's Office Department of Scientific Services Bureau, in other words, the crime lab.
Okay, and if you could tell the jurors what an ASCLAD report, an ASCLAD lab report is, that, in other words, describe what the nature of these documents are.
When a laboratory applies for a accreditation, this is a process. And there is an association called the American Society of Crime Laboratory Directors, and they have a laboratory subdivision that has suggested techniques and parameters for accreditation. If your laboratory wants to meet these particular standards, safety protocols in place, and if you meet their standards, then you have formal recognition by a third party outside the laboratory that you have an accredited facility.
Okay, and so these auditors, would a good analogy be like if an accountant would go audit somebody's financial records and they would create a report regarding that?
Someone from outside the business.
Okay, and so this would be somebody from outside the Sheriff's Department, Crime Laboratory, or people, a number of people would come in and go through their laboratory and then issue an audit report. Is that correct?
That's correct. The process involves looking at the facility itself, whether people have adequate space to work, whether it's a safe place to work, the procedure, and do they provide testimony, and are they qualified to provide testimony regarding the tests that they do.
Okay, and so are the crime laboratory's procedures, in order to be ASCLAD certified, do they have to be in writing?
Yes, they do.
Okay, and I can't had right, correct?
That's correct. The Oregon State Police Crime Laboratory System was one of the first in the United States to become accredited. We were accredited in 1985, and I worked within the system as a forensic scientist, and then when I went into management, I managed an accredited laboratory, and also as a manager, I conducted internal audits of other laboratories within the system annually.
Okay, so basically a laboratory gets audited, and if you're work for that laboratory, you have to cooperate with the auditors, correct?
Yeah, it's accreditation is a voluntary process. If you want to be recognized as an accredited laboratory, you have to follow their guidelines.
Okay, and in addition to your work with the certification process through ASCLAD, you were asked by ASCLAD to actually be an auditor to go to other laboratories to audit their labs. Is that correct?
It wasn't through ASCLAD. There's two processes. Number one, every 5 years or so, a group of people from outside days, they're going through reports and so on. You're also required every year to conduct within your system internal audits. And that's what I did, is I went to other laboratories within our system and assisted in the audit process.
Okay, and using the ASCLAD
guidelines and so
Using
forth.
the ASCLD guidelines.
And the ASCLD requirements and guidelines and rules of the way that labs are certified, are they the same throughout the United States?
Yes, they are.
So the laboratory here would have to meet the same guidelines your laboratory had to meet, correct?
The accreditation process does not dictate what tests that you necessarily run, but it dictates what you do to validate those tests to ensure that they're accurate.
So you looked at, pursuant to our request since you were last here, you looked at the audit records for the Los Angeles County Sheriff's Department Crime Laboratory, is that correct?
Yes.
Now, can a laboratory or laboratory personnel that go to crime scenes, can they get certified in different areas of work? In other words,
Dealing with crime scene processing?
and other things.
Yes, there is a module within ASCLD for certification for crime scene processing.
And what is it meant by crime scene processing? If you could just sort of say, explain what the scope of that job or that work is.
Again, so it would look, you as an auditor, you would go in and see if they have the proper equipment, if it's done, conducted in a safe manner. For example, do they have things to put on their shoes? Do they have masks to wear? Gloves? Do they take adequate notes and proper photographs? Do they write reports that reflect the findings that are in their notes? Crime scenes vary considerably, of course, from one to another, so the accreditation for crime scene processing deals more with the more general aspects of it.
Okay. Would it deal with scientific or procedures that are utilized at crime scenes, such as, let's say, luminol testing and things of that nature?
Yes.
Okay.
If not already documented in another section of the laboratory.
Oh, and with reference to the Los Angeles County Sheriff's Department crime laboratory as it relates to crime scene processing, were you able to tell from the audit document whether or not they were crime scene certified sort of by ASCLD?
Objection, Your Honor. I think we have a foundational problem.
What's the foundation?
It appears to call for hearsay, as the documents in front of the...
Well, but I think that he can interpret documents, and based upon the documents, he can come to a conclusion. I'm going to allow him to testify.
For this accreditation process, which began in 2004, the laboratory chose not to seek accreditation for crime scene processing.
Okay, so it wasn't like they sought accreditation and failed, they just didn't apply for it, is that correct?
That's correct.
Okay, and that was, okay, now with reference to the accreditation that the Los Angeles County Sheriff's Department had, were they accredited as of 2003?
Yes.
Okay, and did they go through some type of accreditation review in 2004?
Yes.
And can you tell the members of the jury what that process was in this particular case?
As this document that I have in front of me states, there were a number of people on the inspection team. They initially came to the crime laboratory on December 5 through December 10th of 2004 and conducted an extensive investigation of the laboratory. Some of the findings were appealed to the ASCLD board. In other words, there were some areas that the team found that they may have disagreements on. The board made decisions on the appeals on April 8th of 2005. And then there was some follow-up remediation documentation provided for review on November 27th of 2005 and also March 11th of 2006. So there's a process of discussion that's taking place between the ASCLD accrediting body and their inspectors and the laboratory itself. No additional site visits were required, and a request by the laboratory to maintain and extend their accreditation until April 12, 2006 was granted by the board in January of 2006.
Okay, so their previous accreditation was going to expire, but they asked for an extension during this review process?
Right.
And you said something about remediation. In other words, what does that mean? What's involved in that?
The laboratory may have a differing opinion than some of the members of the inspection team. and so they can ask for a review, and it's not uncommon. And then the ASCLD board, the accrediting body, can determine whether or not these issues fit within their criteria or not. They are still the accrediting body. And if the laboratory disagrees and it is what is termed an essential, the whole accreditation process is voluntary, so they could elect to opt out or to conform. They have that choice.
In other words, if the laboratory disagreed, they could either withdraw their request for accreditation, or they could then comply with the requirements of the laboratory accreditation board?
Yes.
Okay, so while this was going on, were some changes made after December of 2004 to eventually come into compliance with the ASCLD requirements?
Yes.
Okay, I want to focus on, and were there approximately over 10 auditors that were involved in this laboratory audit process?
Yes.
Now, does the ASCLD accreditation board, does it have requirements?
Yes, they do.
Okay, how does that work?
They have a series of standardized questions that they have, and I have a copy here with me, that when they conduct an audit, that basically the questions that are asked as they travel around the United States are the same questions. So laboratories there is uniformity in the process of the inspection. And there are basically three categories. There are those that are called essential. For example, a safe working environment is an essential. And area that fall under the category of essential, you have to meet all of those if you want to pass.
So essential would be the more critical requirements, is that
Right,
correct?
be the more critical.
Okay.
They have others that are important, and they have some that fall under the classification of desirable. You do not need to meet all of those in order to pass the inspection. It's just nice if you can.
Okay. With reference to essential requirements, were there some changes from the initial site visit in December of 2004, then eventually were there some changes before the laboratory was eventually accredited later on, a few years later?
Yes, there was.
Okay, and did any of those requirements deal with proficiency testing?
Yes.
Okay, what was that, if you could tell us?
There was one question which is 1.4.2.5, which is an essential. Are the procedures used generally accepted in the field or supported by data gathered and recorded in a scientific manner?
Okay, what was the original determination?
The report states the laboratory reports the unqualified identification of human blood based upon the results of 3 tests which are not specific for human blood.
What is meant by the words not specific for human blood, if you could explain that to the members of the jury?
There are a number of tests that will identify or we call presumptive or that are indicative of the presence of blood. A visual examination is one of them. You have a shirt in front of you and has a red stain on it, it looks like blood. That's a presumptive test. As an examiner, you can't conclude that it is blood at this point. If you want to follow the accreditation plans, you have to perform further tests, number one, to confirm the fact that it's blood beyond just a visual exam. And then if you want to identify it as human blood, there are additional tests that need to be performed.
Okay, so if I saw just a spot that looked kind of reddish, like the appearance of blood, that would just be a visual observation, is that correct?
Right. It is acceptable in your reports if you only, perform these initial tests, if you put in your report that these are screening tests or indicative of the presence of blood, or you performed a presumptive test that was positive. It's how you word your report. You can't perform a screening test and then jump to the next level that says I found blood.
Okay. Could you explain what this finding was and what it means and why the inspectors went to that finding?
Well, what they found is that, and what they requested in a supplemental finding, they state the biology manual was modified in May 2005 to require qualified reporting of the identification of human blood when results are based upon nonspecific tests. Review of 4 case records confirmed compliance with these policies by using the words indicates or presumptive in reports to qualify the results.
Okay, would that include the visual identification of blood, both microscopically as well as visually with the naked eye?
Yes.
Okay. And so in 2003, this particular procedure wasn't in place with the reference to the laboratory, is that correct?
The generalization here does not speak to what the inspectors found, other than they found the identification of blood in some reports based upon screening tests. I don't know.
Before you testified the first time, and since we got additional procedures that were result of this audit, was there any procedure in the biology procedures, identification of blood, by looking at substance through a microscope? If there is no written procedure for the identification of blood by way of a microscope, then that could never be approved by ASCLD. Is that true? Procedure
requires a written procedure, and that procedure also has to be validated, which means you have to have demonstrative proof that your chemicals are in good condition, that the test is sufficiently sensitive and specific, and that you have all of this recorded somewhere, and your reagents are dated properly, so that you have confidence when you do the test that the test will provide you results that it's intended to provide.
Is there any written procedure and validation for the identification of blood through a stereo microscope?
No.
After the original audit was done, original finding was made of blood.
The supplemental finding is what I already read, is that they changed the wording when they use screening tests to indicate or presumptive in the reports.
Okay. Did the Los Angeles Sheriff's Department Crime Laboratory, did they have any written procedure for the specific identification of blood that they submitted to the ASCLD laboratory auditors?
The auditors would receive a copy of their methods manuals, and those would be the methods that they would be.
And did they have a human hemoglobin assay that they had in their procedures manual?
Yes, they did.
Okay, and describe what that was to the jury, and tell us the difference between what that was and the observation of blood just by using a microscope.
In the report, there is the next step in terms of the procedures that are used is a question that is asked that is also an essential. Are new technical procedures scientifically validated before being used in casework, and is validation documented and available for review? If I make up some chemicals to use in a test, have I checked to make sure that those chemicals are properly made and that you get the correct response? Is the precision, the accuracy, specificity, and sensitivity all there? And that's what they're looking for. In their original finding, the laboratory has conducted validation for human hemoglobin assay, so the analysts could use results in conjunction with a human serum assay to identify human blood. This is a test that's the next step up. First, you see something that indicates the presence of blood. Now we're talking about a test that confirms the presence of human blood. The validation of the human hemoglobin assay did test species specificity, so they did do that correctly. This, however, was performed at a dilution of 1 to 126 and was not assessed for cross-reactivity at higher concentrations. The human serum assay has no documented validation. So they did not keep records of checking to make sure it wouldn't be positive against cats, dogs, horses, and other things.
Hamburger meat, things like that?
Yeah.
Okay, and so that was the only procedure that was actually in their biological procedures manual, that one that you just described, correct?
There was actually a couple of them that will identify blood that was in their procedures manual.
Did any of those include looking at what is suspected as being blood under a stereo microscope?
No.
Okay. I want to ask you just in general, when you try to characterize a blood stain as blood, what are the scientific questions that you ask to try to go through the process to come to a conclusion whether it's human blood? If you could give me sort of a general idea of what that investigatory process is for a crime scene specialist.
Well, someone who works especially in a biology section of a crime laboratory, of course, sees a lot of garments and materials come through that have red stains on them. The first question you ask is it blood? And then what you want to know, what is the species of origin? You can't always assume that it's human. And how closely can it be associated with a particular individual is the third question that you hope can be answered if you have enough. The first test, is it blood? There are a number of techniques that are available. Of course, we talked the last time I was here about a test called luminol. Another one called Kastle-Meyer test, or phenolphthalein is a term you may have heard. A microscopic exam, and there is an old test called the benzidine test also. These are all screening tests that, besides your visual exam, help support that this probably is blood. Then you have what are called confirmation tests, and we talked about in the inspection report one of them. There are actually several that are available. There are very sensitive tests. One of them that is utilized called Hemotrace is sensitive to about 1 in 100,000 dilution. So even on very small quantities of blood, you could determine if it's human hemoglobin.
Okay, so these confirmatory tests tells you it's human blood, is that correct?
Right.
Now the screening tests say it's possibly blood, is that correct?
Right.
Okay, and that would include the luminol, the phenolphthalein, a visual microscopic exam, or a benzene test, is that correct?
Right.
Now the microscopic exam, I want to focus on that for a moment. And before I do that, though, I want to get to the issue of DNA. When a DNA test is done, does that confirm that the biological material that might be blood actually comes from a human being?
The DNA test is human specific. The problem is that you can have mixtures. And so you have to be careful, because if you have a mixture with, say, blood and saliva, your blood may not be of human origin, but you may get a DNA result from a saliva that is present there also that is human origin. So only on human biological fluids, but one has to be cautious because it is a very sensitive test, and it will react with other substances other than blood.
Okay, so DNA testing, if there's a mixture, you can detect that mixture, is that?
Yes.
Okay. Let's just take a hypothetical. Let's assume that there's some bleeding that occurs, there's a spot of blood, and then there's also some saliva that happened beyond that same area, and they're basically tested for DNA. You could get if it's the same person, you would get one profile, correct?
Yes.
If there's two different people, you would get two different profiles. Is that true?
Yes.
Okay. And neither one would give a profile unless it was human blood and human saliva, correct?
That's right.
Okay. So in doing crime laboratory work, if a screening test is done and it turns out to be negative, do you then go to the DNA process if it's a screen negative?
That would be the judgment of the examiner. If you have a stain that you think that the DNA test might be more sensitive than your screening test, then you might pursue going ahead and doing DNA. But you would be extremely cautious of your results because of the potential of a mixture. Because you can only detect the blood, and for example, if the saliva is there and you didn't run any tests for saliva, you might jump to the conclusion that your results come from the blood stain.
Okay, where in fact you wouldn't know one way or the other, correct? When you test for saliva, is amylase one of the detection methods for saliva?
Yes, it is.
Okay. And the screening tests for blood are sensitive for that process, is that correct?
Most of them are.
Like, let's talk about the Kastle-Meyer or phenolphthalein screening test. How sensitive is that, if you could sort of explain to the jury what kind of dilutions one might get and still get a positive result?
In your validation process, when you make up new reagents, and then also part of validation is before you conduct a test, you have to test the reagents against a positive and a negative control. But during the initial process of making the reagents, you will make a series of dilutions of blood to determine how far out this blood can be diluted. And you can still get a positive result. Phenolphthalein tests under optimum conditions could detect blood out as far as 1 to 100,000 dilution.
Okay. Now, if you see a visible spot that you suspect visually might be blood and you do a phenolphthalein test, should you be able to get a positive result?
Normally, yes.
Okay. Phenolphthalein can actually detect blood that's invisible, that's been smeared and not even visible. Is that correct?
That's possible.
Okay. Now, I want to ask you to look at some exhibits. You were asked, Mr. Pex, to bring with you some pictures of blood that are observed under a microscope. Is that true?
Yes.
Okay, and I want to go through a number of them and ask you to identify the pictures that you were asked to bring and tell us what kind of microscope it was. If we could have we'd ask that this be marked next in order, Your Honor.
F11.
Okay. Is this image here known as a photomicrograph?
Yes, it is.
And tell the jurors what a photograph like this is.
What I did here is I placed some of my blood on a glass slide and just allowed it to dry. I have a regular compound microscope, and the minimum magnification that I have is up 100 times. So what I did, and I have a camera that is on a microscope, and I photographed a portion of that dried blood, magnified 100 times, and that's what it looks like right there.
Okay, so
as it dries, these cracks form as the blood transitions from a liquid to a solid.
Okay, so you see what appears to be just a reddish, kind of a cracked surface on a slide, a glass slide. Is that correct?
Yes.
Okay, and there's actually light that's coming through the slide, so you get a full view of what's in the picture. Is that true?
Yes, the light is transmitted from below.
Okay, do you see more when you do it that way than if you took a microscope at 100 magnification and you just looked at something that was like on a garment?
I've done it both ways. It depends on how thin the stain is. You can make a glass smear of a liquid sample so that your cells are only one layer thick. And with transmitted light, you can see at a higher magnification the cells.
Okay, this would be at 100. You don't see any cell structure at 100 magnification, is that correct?
Not on a crust like that.
Okay, and what would be the difference of looking at blood like on a microscope slide as opposed to looking at it on a garment? In other words, let's say on a coat or a jacket or something along those lines.
Glass is non-absorbent. That's about the only difference. A garment is normally absorbent, so some of the blood would absorb into the garment.
Now, if you were to look at this same glass slide under a stereo microscope instead of a compound microscope that you use, would you see more or less detail in this particular slide?
It'd be about the same.
Okay.
I've done it both ways.
And you still wouldn't be able to see the cells themselves, is that true?
No, they have, as the liquid fraction, the water has dehydrated, these proteins and the solids within the blood have coalesced into a solid.
Okay. Now, we're going to ask them another photograph B, and take a look at this and ask that be marked next in order.
G11.
You recognize what this photograph purports to be?
Yes.
Can you tell the jurors what that is?
This is an example of where I took a glass slide and spread the blood out so it is very thin.
Okay.
And is basically only 1 or 2 cells thick. And you are looking at that area on the glass slide at 100 magnification in an unstained condition.
What's the difference between when you stain something and you don't stain something as far as looking at something under a microscope?
Well, there are a number of stains that are available that clinical laboratories and forensic laboratories have available for blood. In a clinical laboratory, you may be interested in looking at the white cell fraction, and if a person has an infection, they may have a certain increase in certain types of white cells. If you stain the slide, you can see all of these characteristics better at higher magnifications, but normally you're looking at 400 to 1,000 power when you're looking at these white cells and red cells.
Okay. In other words, you need a much stronger microscope to look at it at a closer level, is that correct?
That's correct.
Okay. So this would be a smear that would be different than a crust of blood. Like, let's say if there was a stain on my coat here and it was just a crust of blood, a little spot, that would be more like the first photograph, is that correct?
Yes.
And if it was smear on my coat, that would be more like this photograph, is that correct?
The glass non-object surface, I don't think you could reproduce this on a garment.
Okay. Now, are you able to see when it's thinned out, 1 or 2 cells thick, are you able to make out the cell structure at this level of magnification?
Not with certainty.
Okay, and can you, would looking at blood, and this is blood because you put your blood on it, correct? Would look at this and basically make a statement, if you didn't know it was blood, that it was human blood?
Well, what I would do is, if I looked at this, initially I would conclude that it might be blood. It's indicative of blood, and then I would perform a confirmatory test.
Okay. Or DNA testing, is that correct?
Yes.
Now, if you saw this and you tested it with phenolphthalein, what would be the conclusion if it was positive or negative? In other words, what would be the information you would get?
A visual examination and the use of phenolphthalein is 2 screening tests.
Okay.
And still the final result is still 2 screening tests. Confirmation requires one of the other tests to be performed.
Okay. With reference to blood, I'm going to ask you to look at another photograph. C. Ask you to...
Do you want this marked?
Yes, please. 811, please.
Yes.
You recognize what this photomicrograph appears to be?
Yes.
What is it?
What I have done is taken the original crust that you saw in the first photograph, and I've taken a pair of tweezers and broken it up into islets of blood in little fragments.
Okay. Can't see the round cells, but you can see the reddish material, is that correct?
That's correct.
Okay, now the next one, photograph D, next in order, which would be
I11.
I11. And what is this photomicrograph, Mr. Pex?
This is just another photograph of the same material in a different area.
Okay. And I want you to look at the next photograph and tell me, what is this a photomicrograph
Would you
of?
like this marked?
Yes, next in order, Your Honor.
J11.
This photograph represents a thin coating of paint.
Okay. And what would be the way that you would confirm whether or not this was blood, even though it looks red?
Well, it looks red, so that would lead me to perform a screening test, such as phenolphthalein. And if that test was negative, I would probably stop at that point. I may, if I want to know what the substance is, I may go to some elemental methods that would tell me if it's paint.
Okay, when you say elemental methods, are there things that look like blood that turn out not to be blood that are routinely encountered? Sure. Okay, so it'd be like a mass spectrometer where you're trying to figure out what kind of paint, kind of chemicals are.
Yes.
Okay. Now, the next in order, Your Honor.
K11.
Do you recognize what's in this micrograph?
Yes, this is I took a tomato and took a thin slice of the skin of the photograph.
Okay.
That's correct.
Okay. Is it possible to visually identify a substance as blood at 100 magnification with a microscope?
I never have.
Okay.
Not for legal purposes.
Okay. You can suspect it's blood, but you have to do further testing.
That's correct.
Very good. Thank you, Mr. Pex. I have nothing further.
Thank you. Cross-examination.
Thank you, Your Honor. A trained histologist either, are you?
Histologist is a person who specializes in tissues. It all depends on degree of training. I took histology in college, and I certainly viewed a lot of tissues during autopsy.
Sure. Someone who has advanced degrees in the study of histology and the study of organic tissue might have a little bit more experience than, for instance, someone who just took classes in college or and got a degree in something else. Correct?
I guess would have more experience with types of cells. In the action of red cells, that's pretty common.
Okay. If I could, I want to talk about the ASCLD stuff first, very briefly. I don't want to get bogged down in that, and then I want to talk to you just briefly about the bloodstain pattern stuff. Beginning the examination indicated that there were suggested techniques by ASCLD for crime labs across the country, correct?
Yes.
Okay, and those suggested techniques establish certain standards so that crime labs can begin to have some uniformity with regard to standards and protocol that they develop and they engage in, correct?
Yes.
Mr. Pex, this is a voluntary program, correct?
Yes, it is.
And it's been developed by ASCLD, the body that you talked about with Mr. Plord, to establish this uniformity, correct?
Yes.
But if a particular lab, say a lab in New York or a lab in Wisconsin or a lab in Louisiana, happens not to have sought accreditation for whatever reason, there could be a plethora of reasons, but for whatever reason they have not sought accreditation through ASCLD, that doesn't mean that their procedures, their scientific protocol is insufficient or subordinate to those who have sought accreditation, correct?
What that means is you don't know the answer.
Okay, but in other words, it doesn't necessarily mean that they couldn't perform the same kind of procedures as an ASCLD accredited lab, they just haven't sought accreditation.
That's right. They may perform the same test, but they haven't demonstrated that those tests are valid.
Okay, and ASCLD doesn't set protocol. They simply take a look at your protocol and make a determination what that protocol meets certain. Correct.
ASCLD is actually, inspection is actually a process.
Okay.
And as I said, an independent body, separate from the laboratory, independent inspectors that come in to determine if what you do fits within the scientific community. There are valid methods, that you have validated those methods, that you work in a safe working environment. There are a lot of qualifications that are outside tests.
Okay.
Whether you have enough space to work, for example.
Sure. For instance, taking Oregon State Police, the lab that you ran for a number of years, the lab that you worked at for a number of years before that, before 1985, would you consider that lab, the Oregon State Police lab that you worked at and ran, to have engaged in scientifically sound protocol?
Yes, we did. Yeah.
Okay, but then in 1985, you simply got a third-party body, this ASCLD lab certification, to say, hey, we're a third party, we're independent, and bless you, go forward and prosper. You're doing the right stuff, correct?
That's right.
All right. With regard to certain modules, I'm using that word, I don't know another word for it, subcategories, I guess, of ASCLD certification. There might be some categories in safety. There might be some categories in the biology section, physics section, the trace section, all of which, the module that Mr. Plord asked you about, crime scene processing, that is probably the newest of all of the modules to be adopted by ASCLD, correct?
That's correct.
So until maybe 4 years ago or so, 5 years ago maybe, ASCLD didn't even have a certification process or an accreditation process for crime scene investigations.
That's correct.
Okay. And you indicated, I think, to Mr. Plord, that according to the documentation that you have in front of you, the Los Angeles County Crime Lab did not seek accreditation under that particular module, but there could be a number of reasons why.
I have no idea why they did not.
Okay,
correct.
But that certainly does not mean that their crime scene processing protocol is substandard or subordinate to those who have sought that.
All it means is just not validated by a third party.
Okay. And the audits happen normally every 5 years, is that right?
That's correct.
Review or appeal process. Set of auditors come into a particular crime lab, let's say Oregon State Police Crime Lab, and they look at certain procedures and protocol and say, hey, look, your folks haven't taken a, let's say in the biology section, your folks haven't taken a proficiency test recently enough. And so they mark you down on the accreditation score for that. Then you, as the director of that crime lab, might say, hey, wait a minute, time out, folks. There's a different type of procedure that we have in place. Let's review that and see if you guys can take another look at what we do, our protocol, and see if it meets your standards. Right?
Yes.
Okay. In other words, those processes and the processes of trying to maintain a level of uniformity across this country in crime labs across the country is a very fluid and dynamic undertaking, wouldn't you say?
I think the standards by the board are pretty solid. I think that the inspection teams, of course, are made up by individuals from other places around the United States, may have varying opinions upon how they think something should be done. If you disagree with that, then you certainly have the right to appeal to another level, to the board, that you feel what you're doing is right, even though this individual may not.
Okay. Fair enough. So in other words, reasonable minds can differ about certain specifics on protocol between ASCLD lab, the accreditation board, and the particular directors of particular labs.
Yes.
Okay. You indicated to Mr. Plord that there were 3 degrees of standards, if you will. Those that ASCLD lab considers, or I should say ASCLD, because that's the broader body, correct?
Yes.
And then ASCLD lab is a subordinate body to that.
Yes.
Okay. ASCLD, has 3 degrees, those that they deem essential, those they deem important, correct?
Yes.
And in your review of the documentation of the Los Angeles County Sheriff's Department with regard to those that ASCLD deems essential, the Sheriff's Department actually scored a perfect score on that, correct?
Objection Vegas?
In the last, the audit that you're reviewing.
Objection Vegas, it's on?
Well, what time periods did you cover?
2004 to 2006.
Okay, within that period. Now, Mr. Jackson's question, within that time period.
They scored 100% on the areas that were applicable for their laboratory.
And then with regard to the important areas, I think you have to have an 80% or better, correct?
Yes.
And they scored an 80% or better. As a matter of fact, I think they may have scored a 95 or something.
You can have, ASCLD has some requirements that might not be applicable to laboratories. For example, there may be tests that some laboratories perform and others don't. So the questions that are associated are not applicable.
Okay. And then with regard to desirable, they passed, I think you have to have a 70% or better compliance rate with that, and they passed that too.
Yes.
Okay. So they were in compliance according to ASCLD with all applicable procedures and protocol.
Eventually, yes.
Okay. With regard to the proficiency testing that Mr. Plord asked you about, he asked you a specific quote, to highlight a specific quote, the finding being there were some unqualified results for human blood, et cetera, et cetera. I don't know the actual quote. You have no idea, based on the findings of those auditors, whose reports they were looking at?
No, I do not.
All right. Certainly, there's nothing to suggest that they were Lynn Harold's reports, Dr. Harold's reports that they were looking at.
I have no idea whose reports they were.
And of course, the biology section and the trace section have a multitude of folks working in them in the Los Angeles County Crime Lab, correct?
I would assume that.
Okay. You indicated there's no such thing as a, see if I can get this right. We learn things in trials all the time, and this is something that just amazed me. It's not as easy to, you can't just like on CSI, take a swab and tap it to a spot of blood and say, oh, voila, that's blood. It just comes up, as blood. It's not quite that easy, is it?
No, that's why I don't watch CSI.
I'm actually trying to.
I imagine you don't watch Perry Mason either.
Fair enough, fair enough. The fact is that there are certain screening tests for blood, correct?
Yes.
And that's all they are. They're screening tests, is that right?
That's correct.
And then there are some pretty delicate and pretty specific confirmatory tests, one or two confirmatory tests that will actually tell you this is blood.
And can tell you this is blood or tell you this is human blood.
Okay. Species specific.
Yes.
All right. Now, to do that test, that last confirmatory test, oftentimes if there's a very small stain, you'll use that stain up to make that determination. Trial. Blood, correct?
That's correct.
We did a DNA sample, and you see that in cop shows all the time. We did a DNA sample, and we've got your blood on the gun or whatever. That is actually somewhat inaccurate, correct?
It may or may not be accurate.
The DNA could come from skin cells, it could come from saliva, you could drop a tear if you think you've just gotten caught. And that'll all come back to your DNA, correct?
It could, yes.
All right. Now, let's change that a little bit. If the stuff you're testing is red, and it's liquid, and it's in a pattern that suggests that there's other blood around, then you can be pretty sure that what you're testing in the DNA analysis is blood, correct?
You said is liquid.
I did. Let me rephrase that. Maybe I can go this a little bit more succinctly. There are certain tests that you indicated to Mr. Plord should be done to make a determination if something is blood or not, correct?
Yes.
All right, let's go through those very briefly. I think you told Mr. Plord that what you want to first do is look at it.
Yes.
Let's glance down and see, does it look red or is it blue? In other words, make a visual exam, correct?
That's correct.
Then you might want to engage in a screening test like KM or Kessel-Meyer to make a determination as to whether or not that comes out positive, correct?
Yes.
All right. Then you might want to look at it microscopically and identify what you can microscopically on that particular stain, whatever it is that you're looking at.
I think I probably would have done it in reverse.
Look at it microscopically
First,
Then the KM test.
and then determine what I'm going to do with the sample.
Okay. Then you might take, if for instance there's a pattern there, you might take a random sampling and do some DNA testing on those random samples and see what that result comes out.
That's correct.
All right. If all of that indicates, let's say your visual exam shows in your experience, and you've got a lot of experience, if it looks like blood, then you do a microscopic exam, and even on closer inspection, it looks like blood. There's a pattern that looks like age in the KM positive, the KM testing, and that comes out positive.
Okay.
Then you take some random samples and do a DNA test, and that comes out positive for, let's say it comes back with one of the people at the particular scene where the pattern emerged. You as a scientist would be relatively comfortable at that point saying, what I'm looking at is blood.
Yes.
Okay. So as long as, if I understand your testimony correctly, Mr. Pex, as long as you are somewhat careful about taking steps, each step building on the next, and taking the whole complexion of the event, if you will, that you're looking at into consideration, you can, as a scientific professional, come to a conclusion at some point that something is blood or not blood.
That's right. The problem comes is that whatever reports you write have to reflect the tests that you performed. And
Okay.
this is what the problem that ASGLAD had initially.
So, for instance, if the reports indicated the word apparent blood,
Yes.
like in someone's handwritten bench notes, if it said reviewed jacket, apparent blood, or reviewed buttons, apparent blood,
Right.
that would be appropriate.
A reviewer would know that you probably ran a screening test and got a positive screening test, didn't go any further.
Okay. You said that under questioning by Mr. Plord that there is no specific ASCLAD approved method for visually identifying blood, correct?
That's correct.
There are procedures, or I should say specific procedures of individuals who have specialized training and talents to employ those talents and training during the process of their crime scene or crime investigation, correct? That was a really long question,
It
wasn't
was a long question, but I think I can provide a shorter answer than the question.
Good. I'm counting on you.
The answer is that the certification is for the laboratory. And individuals may have specialized talents, but they still have to conform, if you want to remain accredited, with the accreditation process. You cannot have certain protocols in the biology section and have different protocols in like the trace section. The certification is for the laboratory, not for the sections. And your testing has to be uniform. I guess that wasn't shorter.
Still shorter than my question. With regard to, let's use an example. You and I spoke out in the hallway just a few minutes ago, and actually you had a fascinating example. If someone, I think you said that you are aware of a crime scene that included a little bit of trace evidence in the backseat of a car or something like this, and someone had to go out and look at what this little tiny thing was. And somebody made a determination that it was a sequin off of a blouse or off of a shirt of some kind.
That's correct.
All right. There's no ASCLAD for visually identifying sequins, for instance.
No, and that's why there is a catch-all in there for unusual circumstances that might come up. A coworker's case, and it was a homicide. The victim wore a blouse that had little glittery sequins on them. In examining a vehicle, and these little sequins. And it turns out that manufacturers of these manufacture them in certain shapes to represent their particular product. And so, there's a learning process you go through here things happen that are unique that you just can't write a protocol or a method for just everything that you do. How you approach it, you can, but you cannot include everything.
As long as the protocol in place at a particular lab includes taking certain precautionary steps, documenting every step you take, and then engaging in peer review in the lab itself, that is something that ASCLD certainly looks at and encourages, correct?
That's correct.
And it's that kind of cross, I don't know what the word is I'm looking for, cross-confirmation peer review that is sort of the hallmark of doing these kinds of tests and this kind of investigation.
Well, there are actually a couple of different peer review processes. One is the technical peer review, where someone else would look at these sequins and agree with you that's what they are. Then there is an administrative peer review where someone will look at your notes and determine whether you have adequately performed sufficient tests for the conclusions that you formed, and that a regular viewer would come to the same conclusions based upon your notes.
And you're aware that the Los Angeles County Crime Lab does in fact employ a technical peer review process before any findings are memorialized in a report?
Yes.
With regard to the last point or points that Mr. Plord was making with you, he put on the overhead a picture of I think it was a photomicrograph of a tomato, a photomicrograph of some paint, and photomicrographs of some blood, your blood, correct?
Yes.
Is there a reason that in your profession you call yourselves bloodstain pattern analysts?
Yes.
Is there a reason that the word is used in there?
Yes.
Could you explain that for us?
In the commission of a crime, various assaults can occur and comes to the surface, and blood can be cast through the air. And you've probably heard about this before, but there are basically three categories. One is blood that just falls from the body by gravity, like someone has a bruise, for example. We refer to this as low impact or passive blood spatter. It just falls by gravity. Then you have circumstances where someone has a bloody nose, but he's in the middle of a fist fight, and more energy is imparted to the surface of that blood, and you get smaller droplets that are formed that travel through the air. This we refer to as whatever it lands on creates a pattern, and so this would be like a medium velocity impact pattern. In a shooting circumstance, you have, again, increased energies involved. The size of the droplets get even smaller. And again, when these droplets fall on a surface, the appearance of a particular area is referred to as a pattern of blood.
And in your analysis, either in field investigations or if you do a lab analysis later of, say, for instance, clothing or garments, you have to take into consideration the overall picture of the crime scene itself. You don't just look at the garment in a vacuum, correct?
That's correct.
And you don't look at one particular spot on the garment in a vacuum either, do you?
No.
As a matter of fact, that would be incompetent for a bloodstain pattern and field data or a lab and everything else, correct?
Your question's a little vague, but I will agree with you at this point.
I'm getting used to that after all this time.
Ladies and gentlemen, keep in mind the admonition. We'll be in recess for 15 minutes. Thank you.
Thank you.
Okay. Part 2. Part 2. James Peck Part 2. Quit buffering. Stop it. Stop it. Why do you buffer? I hate this website. They need to get their crap together. Get your crap together, Court TV. Come on.
Order, court again is in session.
All right, all parties, jurors, alternates, and the witness are present as heretofore. I understand there's a question. We started with F11, and you believe that we had an F11?
We did, Your Honor, from last week. It was marked on the afternoon of the 9th, so that means we should have started with G this morning. So everything needs to be adjusted by one letter down there.
Thank you. Just let me make a note. What was F11 then?
Last week, F11 was a 3 letters.
Okay. Thank you. All right. So we're now G through L. Thank you. You may proceed.
Thank you, Your Honor. Just before we left off, Mr. Pex, I was asking you about whether or not it's appropriate to take the entirety of the pattern into consideration when you begin an analysis as a bloodstain pattern analyst at any crime scene or even back in the lab.
Yes.
And I think you indicated to the jurors that it would be inappropriate to simply look at one or two things in a vacuum. You have to look at everything kind of together in a totality of circumstances, correct?
That's correct.
Now, if you had a situation where, and this is in respect of the, or with respect to the photograph of the tomato, the photomicrograph of the tomato, the photomicrograph of the paint. If in fact you had a circumstance where there was a shooting, for instance, at a crime scene, and a person emerged holding a gun in his hand, and there was blood at or around the hand of the gun. The person was wearing a jacket. Certainly you would take that into consideration if you were to later look at that jacket to make a determination, initial determination of what was happening, correct? And what your investigation revealed.
Objection beyond scope and also begging you to not.
Overruled. You may answer.
As a scientist, I use inductive reasoning, and I would take these types of facts under consideration.
All right. So,
not necessarily make judgments upon them.
Sure, but you would certainly consider the circumstances surrounding how you got the jacket. Where did it come from, and where had the jacket been previous to you getting it?
Yes.
For instance, if it had been on a human being just before that human being was seen with a bloody gun in his hand, that might be a consideration if you were to look at, for instance, transfer stains or other stains on the jacket.
Yes, again, one would consider the quality of the information.
Okay.
You would take it under advisement and continue with your physical evidence exam.
And as you continue with the physical evidence exam, if a pattern began to emerge, for instance, if that jacket had a relatively consistent pattern of spatter on the jacket, and the spatter was around a millimeter size or sub-millimeter size in diameter, I guess it would be, and if, in fact, all of those stains, those millimeter-sized stains were looked at visually, as you said would be proper protocol, they all appeared to be red. They all appeared to be about in the same general size range. Visual examination, all of those stains were microscopically, and the microscopic examination was consistent with blood, and the visual examination was consistent with blood. And then random stains in that same pattern, random stains were taken and KM tested, or Kessel-Myers tested, and those all came out positive. The ones that were actually brought up onto the Q-tip were positive.
Excuse me, this is a hypothetical. It's a hypothetical. The strength of the hypothetical is based upon the facts of the hypothetical. You may proceed.
Thank you. And if those KM results came back positive, and then if certain other of those stains in this same pattern were randomly DNA tested, they were cut out and DNA tested, and all of those came back to the victim in the case, victim of a gunshot, certainly as a bloodstain pattern analyst, you would be comfortable saying that the pattern that appears on the jacket, those small red particulate stains, were consistent with blood, rather than, for instance, the third from the left might be a tomato.
Overruled.
Difficult question to answer, mainly because every circumstance is slightly different. If I had examined the item and I felt that, as you said, every stain had the same appearance to it, it is not necessary to test every drop of blood within a pattern. And I think that's where Mr. Jackson is going. It is important to test a representative sampling of the pattern. It's a couple of things need to be considered. One is do you need to test? Do you need to retain some of the, you do not want to consume all of the sample, so you would test a representative portion of it.
And that, in your mind, would be the proper protocol for making a determination about a pattern of blood that appeared on a particular garment?
Yes.
Thank you, Mr. Pex. That's all I have.
Thank you. Redirect.
Mr. Pex, I wanted to follow up on a couple of the areas that Mr. Jackson talked about then. First, he was asking you about patterns and whether you test every stain within a pattern. And when you see a spot that looks like blood and you want to test presumptively whether it is or is not blood, there's a particular procedure that you can utilize known as a KM or phenolphthalein test to do that, correct?
That's correct.
And the proper procedure is to take a swab, which is basically, it looks like a Q-tip that's sterile, and you moisten it so that you can touch that stain and draw onto that swab just an infinitesimal amount of that stain and then do a presumptive test, correct?
That's correct.
That's a very common procedure that criminalists like you have been doing for way before DNA was started, been done for 30, 40, 50 years or more.
That's correct.
Okay, and that's a routine thing that a criminalist does sometimes at a scene, sometimes when a garment is examined. Is that correct?
Yes.
And there's no problem with using up a whole stain to just touch it and draw a little bit on to do this presumptive test. Is that correct?
A portion of a stain, that's right.
Right, just a very small portion of even of a little speck of blood. Is that true?
That's correct.
Okay, and then if you get a positive reaction, then you have a choice. You can go forward and do further testing to see if it's human blood, correct?
Yes.
And you can even do DNA testing. You have that option also. Is that correct?
Yes.
Okay, and if you see a pattern and you get some negative Kastle-Meyer or phenolphthalein test, and you get some positive, and you're doing the test the same way in all these different spots, that tells you that some of those stains may not be blood. Is that correct?
That's correct.
Okay. And basically, when you look at a pattern and you look at a garment, you look at the whole picture, but you also consider other stains that may or may not have happened during the incident. Is that correct? Whether they're on the garment or on another garment or on another person, etc. Is that true?
Yes.
And try to see if they fit together or don't fit together, that type of thing. Is that correct?
Yes.
Okay. And the phenolphthalein procedure to presumptively tell you whether the stain could be blood is a screening test, and it is approved, it is used by laboratories throughout the United States. Isn't that correct?
That's correct.
And when a laboratory is certified by ASCLD, they have to put, even though it's a common test, they have to put their procedures for Kastle-Meyer or phenolphthalein testing in their laboratory manual. Is that correct?
Yes.
And they have to document scientific literature and or in-house testing as to how they do this test. Is that correct?
That's correct.
And with reference to the Los Angeles Sheriff's Department Crime Laboratory, they did that. They had a Kastle-Meyer test described with all the validation requirements in compliance with ASCLD. Is that correct?
Yes.
And when you talked about this audit that was done of the Sheriff's Department that started in December of 2005 and then ended years later, and you answered a question as to whether or not there was 100% compliance with the essential requirements. That was at the end of the audit process after changes were made. Is that correct?
Yes.
And when the inspection was done and the audit was done in December of 2005, there was not 100% compliance. Is that true?
That appears that way, yes.
They were deficient in the blood identification procedures and policies as of that time. Is that true?
Yes.
They failed the requirements as of that date. Isn't that true?
It appears that way from the report.
That misstates the evidence. There's no failure.
Sustain is to the phraseology you're using.
Let me ask you this. When an audit is done, it's led by a person from ASCLAD, or there's somebody that coordinates the audit. Is that correct?
Yes.
In this particular case, do you know who that was?
Mr. Glenn Johnson was the team captain from Texas Department of Public Safety in Austin, Texas.
Okay, and who decides who the audit team was? If there's somebody at ASCLAD that's like the director or the person in charge?
Yes, Mr. Ralph Keaton.
Okay, and he was then, he is now. Is that correct?
Yes.
You've known him for a number of years, I take it.
I know him, I guess, just through conversations and communication.
Okay, and Mr. Keaton, did you inquire of him as to whether the ASCLAD requirements were the same today as they were back when this audit was done, as well as back in 2003?
Yes, I called him.
Okay, tell us about that.
I had copies.
Appear to call for hearsay with no exception.
Sustain.
Was it your understanding that, well, let me ask you this question, Mr. Pex. I'm going to read you a criteria, an ASCLAD criteria, and ask you if I'm correct, did I read it correctly? And this is a criterion 1.4.2.5.
I would object. I know the question hasn't been read yet. I think we know what the question is going to be. It's going to call for hearsay.
Well, I don't know that at this point, so I'll allow him to read the question. I don't know what the question is going to be once the criteria is read.
He said this question was going to be, did I read it correctly?
Well,
I think we would all assume, I'll stipulate that Mr. Plord can read it correctly.
it's foundational as to this being a requirement of the audit.
Are you familiar with this particular criteria?
Yes, I am.
All right.
Okay.
Proceed.
Was this particular criteria part of the audit process that you've been testifying about?
Yes.
Okay. I'm going to read the audit criteria, and then I'm going to ask you a question as to whether or not it was met or not met in a particular circumstances. Are the procedures used generally accepted in the field or supported by data gathered and recorded is essential for a laboratory procedure? Is that correct?
It is essential for the laboratory to comply with if they want to pass the inspection.
Did the Los Angeles Sheriff's Department Crime Laboratory have a procedure that met this criteria for the microscopic examination of a crust of blood at 100 or less magnification?
Not in any
That
manual.
assumes facts and evidence that it's required at that level of magnification.
Well, I don't know that the question calls for required. He's asking if they had something that matched it. This witness can testify from his review whether he believes they do or they do not, and we'll go from there.
I guess my problem is that question assumes that that's what the protocol requires.
No,
Protocol doesn't require that.
It doesn't assume anything. It's just a question.
Okay.
At this point, if it has no bearing, we'll find out sooner or later. Go ahead. You may overrule. You may proceed.
Do you understand? Remember the question?
The manuals that I reviewed did not have a procedure for the identification of blood based upon a microscopic exam.
And I want to draw back to the ASCLAD accreditation process and the procedures for a laboratory to become accredited. Is it absolutely, positively required that any procedure, in order to meet ASCLAD certification,
Stop it. 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 Stop, 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 stop. Ugh. Why are you buffering? Stop. Ugh. Okay. Okay, I'm gonna reload Court TV. I don't know the time. All the time. The problem is now I don't know where we left off. Shoot. Where were we, guys? I don't even remember. Oh, it put us back where we were. Cool.
Being considered as being part of an alleged crime, you'd want to consider other items or other be involved in that crime. Is that correct?
Yeah.
Okay. So if you have two people involved in an incident and you're trying to determine, let's say, who was holding blood on them, but who had more blood, who had less blood, where the blood was, whether the blood was in a pattern, whether it was had a direction to it, things of that nature. Is that true?
That's true, including the absence of what you would expect.
Okay. Now, if there is a bloodletting event where you know that blood is being shed, then the absence of blood at a particular location may have extreme significance. Is that true, Mr. Pex?
That's correct.
Okay. I want to ask you this hypothetical. I want you to assume that somebody is shot with a gun, assume that there is blood that comes out of the, and that assume further that it's an inside the mouth gunshot wound, and assume that blood is emitted from the mouth as a result of that there was no exit wound. Assume that fact also. You would want to know where that blood went and where it didn't go. Is that true?
Yes.
If it went on the gun, if there was some spatters on the gun, that would tell you that blood came out of that, from that gunshot wound, essentially. Is that correct?
Yes.
Okay. And if there was no blood on somebody's sleeve, that would be important information to consider too.
Yes, it would.
Because just because there's an absence of blood, you know that there's actually blood flowing from that wound. Isn't that true?
That's correct.
Okay. I want to show you Exhibit Y to the 6th. Showing you this photograph, and I want to ask you to assume that this photograph is of the decedent, Lana Clarkson. And if you could take a look at that, what looks like a tadpole. I've used that word. I think I've heard people refer to it as tadpole. Does that have a meaning in the field of blood spatter?
Yes, it's...
What's a tadpole?
Yeah, that's a common term that we use to describe the shape of blood spatter when it strikes a surface at a long angle.
Okay, so it gives you an idea as to what direction the blood spatter was coming from when it hit an object.
Actually, if it's a fixed surface like this desktop, you can measure the length of the stain and the width of the stain and determine the angle at which it strikes this solid surface. Those of us who have been doing this a long time can make approximations just based upon, looking at it visually.
Okay. Now, when an item is on clothing that can bunch up and so forth, does that make it more complicated to determine where it originated from and how it came about?
Yes.
Okay, but in this particular instance, the little dot, which would be Would that indicate that the blood came in the direction that the little dot is pointing?
Well, the blood would have originated opposite where the little dot is located.
In other words, here's the little dot, and opposite, in other words, in
Would come from this direction.
that I'm pointing to now, upwards according to this photograph.
From the lower left towards the upper right.
In the angle where the dot and that little line is, the tadpole.
Right.
Okay. And how do you know that as a blood pen or a person that goes to scenes?
Blood doesn't go around corners. It travels, when it travels through the air, it'll travel normally in a straight line.
So it looks
So
like
you could draw a straight line through the length of that droplet, and you would have an idea of the direction from which it originated.
Okay, and I take it that there's been some scientific experimental validation of this principle that the larger elongated stain and then the dot, that's the way it works.
I know that's the way it works.
Okay, so the blood drop hits, this is called a spatter, is that correct?
Yes.
And it elongates and then a little tiny bit goes further than the elongated portion, is that true?
Yes.
Okay. How does that happen? In other words, what are the dynamics involved in that?
Blood that travels through the air has some momentum, and I have observed high-speed photography of this phenomenon. And when blood comes through the air and strikes a surface like this, you kind of have a wave that goes through, and a little bit comes off of the end and makes that little dot.
Okay. I want to ask you another hypothetical question. I want you to assume that this particular blood drop pattern of this tadpole, as we call it, on exhibit 6Y, or Y to the 6th, I want you to assume that this person was holding a gun in the fashion that I am demonstrating to you. And I'll go right up to you. Some way like this, oriented like this, with the gun pointed in the mouth. Is that blood pattern consistent with the person holding the gun in that fashion?
I would assume from that photograph that represents the left hand. Is that correct?
Assume that that's the left hand.
And then if the spatter is across like this, we know the origin in the case that you're describing would be from the mouth. That blood travels in a straight line, that it would travel across the hand like that.
Exactly as it's shown in that photograph, is that correct?
It could, yes.
Now, let me ask you another hypothetical. Assume the same scenario where somebody is shot in the mouth, but their hands are up like that. Would that particular blood pattern be consistent with the hands being held up like that?
No.
Why not? What's wrong with that?
It would be the same as dropping some blood on this table. You would form a nice round circle. Just because your hands are vertical and it emanates out this way and strikes your hand, it would make a nice round circle here, as opposed to if it goes across your hand this way.
They asked you to look at Defense Exhibit PP. Okay, this is orientated up and down, and I'm going to ask you to take a look at this. This is a right hand as opposed to the other photograph, which was a left hand. I ask you to take a look at this little dot here. Does that, as far as visually, is that consistent with what's known as a blood spatter?
You have a small red dot there. It looks like blood, so...
But not 100% certain?
Not certain, but it looks like blood.
Assume further that DNA testing was done and swabs were taken and human DNA was identified. You still can't say with 100% certainty that the human DNA came from blood. Is that correct?
Well, that's true.
But basically that would give you some indication of human biological material, and if it was a swab of this stain, that would further help identify that as being more likely blood than not, subject to those limitations.
I'm going to object, John. That assumes facts, not evidence.
What are the facts on evidence?
The entire hypothetical assumes facts, not evidence, that particular stain that Mr. Plord is highlighting was swabbed, DNA tested, etc.
Jamie Lynch will testify to the collection of blood stains
Off the back of the wrists.
back of the hands and wrists.
Correct. And that
And
is
they
on-
were taken through DNA testing.
Thank you. There's there is a question. You can debate that at a later time or call witnesses back, but I'm going to allow this person to answer the hypothetical. And then the rate to be given to it will depend upon the facts that have been proven to the jury.
Sure.
You may proceed.
Okay. Why doesn't that look like the other stain? What's the difference between the two?
The difference would be that this one that does not appear to be perfectly round, so it wouldn't be like it fell directly straight down on the surface. If that stain appears and is in its entirety, it looks like it struck that surface at a very slight angle. So could we go back to the previous one for orientation? And that's the right hand, and that would be right about here on this knuckle. So this surface here, if in your hypothetical you're talking about the origin from the mouth, could be perpendicular to the origin, or very close to that. That's probably somewhere between 80 degree to 90 degree angled stain.
Okay. In other words, would it be consistent with somebody holding an object in this orientation to that particular stain?
Yes.
Okay. So the stain just hit it at a more direct angle as opposed to the other one, is that correct?
Yes.
When you want to look at a pattern, well, let me ask you this. Is there any way to look at a stain that, let's say, is on a hand or hands, if there's two hands involved, is there any way to tell with any degree of certainty whether the same mechanism caused staining, let's say, on a garment of another person who is different than the person that the stains are on?
That's difficult to say. It just depends on the circumstance. When you do pattern interpretation, you have to, for example, Mr. Jackson mentioned the white jacket, and consider there in a homicide that there is a single event potentially that may have created this blood spatter, or there may be more than one event. But if you assume that the blood emanated from the mouth, then the pattern on the jacket is to be considered. The pattern on these hands are to be considered, but not necessarily together. They may or may not be, we know that the source may be the same person, but not necessarily the same incident.
In other words, there may be a time difference between the two, is that correct?
I guess that's what I'm trying to say, yes.
Okay. Now, when you look at blood stains and blood patterns, in addition to the proper collection of the evidence, is photography, how does it play a role in the looking at blood patterns, just the visual patterns?
Well, obviously, the most important assessment is your own visual assessment at the crime scene. Before anything is changed, the position of the deceased is changed, and then you document, and that's part of accreditation is documenting what you see, and you do that most efficiently through quality photography.
Okay. So if somebody was in charge of a crime scene and they were the criminalist, such as you've done this how many times?
Lots.
Okay. You've been to scenes where people have done self-inflicted wounds as well as homicide scenes? Is that?
Yes.
Okay. And you document what you see in notes and so forth, and you observe things, and then you photograph it as a follow-up. Is that correct?
That's correct.
And Mr. Pex, the criminalist, there's usually a criminalist that is in charge of a particular scene. You understand how that works, I take it. Is that correct?
Normally, yes.
Okay. In this case, I think there's testimony that Mr. Renteria was involved in the scene, and he was the criminalist in charge. There were other people working with him and alongside of him, but he was basically the criminalist in charge. And he would have certain duties and responsibilities, would he not?
Yes.
In order to meet sort of a level of care or a standard of competency. Isn't that true?
It just varies depending on your experience level and your training.
Okay. Well, one thing would be for him to look at all the blood stains that he could visibly observe. In other words, if there was a blood stain on a item or on a person, to look at those. Is that true?
Yes.
Okay. Like look at the ones that were on hands, for example. You'd want to look at that if you were a criminalist, right?
Yes.
And that person was deceased. You'd really want to look at that. Isn't that correct?
In a case in differentiating between a homicide and a suicide, the blood spatter that's on the hand is pivotal information.
Okay, and if a criminalist went to a scene and did not even take note of any blood spatters that were on a hand, that would be below the standard of care for a criminalist in your experience. Is that true?
That is not what I would do.
Pardon?
I guess my answer is that is less than what I would do or anyone who worked for me.
Okay.
You have to understand and have sufficient training that when it comes to a shooting circumstance, there are certain steps and procedures that you follow. And depending upon the circumstances, if there's a question versus suicide versus homicide, procedures that you need to follow, what's important, what is not important.
And the criminalist would be the person that would make sure that photo documentation is done correctly. Is that correct? The person in charge?
Normally.
All right. Very good. Those are all the questions I have, Mr. Bex. Thank you very much.
Recross.
Thank you. There's about 5 or 6 points that I want to address with you. It's not looking good.
I got a flight this
Not
afternoon.
looking good, Mr. Pex. I'll try. Let's get right to it. Mr. Plord asked you if there was scientific validity. The word he used was, is there scientific validity to the identification of blood just visually? Taken in a vacuum, just visually. Identifying scientifically whether blood is blood just visually, that you're unaware that there's any procedure in place for them just that.
It indicates the presence of blood, and I'm talking about blood on garments and evidence.
All right. Is there scientific validity to the identification of blood if the identification is done visually, and then that is coupled with a microscopic examination, and then that is coupled with a random KM testing, and that is coupled with DNA testing? All of it's taken into consideration before the specific identification of blood.
Objection, vague and incomplete, hypothetical, vague, hypothetical, and also it's vague as to the level of magnification, whether it's at 63 or 300.
There are many parts to this. If you want to go back into that and redirect, I'll allow you. The objection is overruled.
Did you have the question in mind, Mr. Pex?
I think you're going to need to hit me again with it.
Sure. If you couple the visual identification, just on the whatever it is, couple that with microscopic examination, couple that with random KM testing, which comes out positive, and couple that with DNA testing that's done randomly, and that comes back to the victim as human DNA. Is there scientific validity to that procedure?
There is scientific validity if it's within a pattern. We already answered this once.
Yes, we did.
And you don't need to consume every drop of blood within a pattern.
Thank you. Point number 2. See, we're moving through this pretty quick. Thank you for that, Mr. Pex. With regard to KM negative, I want to make sure the jurors are not left with a misimpression. KM, Kesselmeyer's test, will not give you a negative as that phrase is actually used. It will simply tell you that something is not positive. Is that correct?
It is possible that you could get a negative Kastle-Meyer and the blood is sufficiently dilute, perhaps, that the test was not sensitive enough to pick it up.
Okay, in other words, there can be false negatives, correct?
I guess based on dilution, yes.
You have to, the first thing is you have to make sure you touch the stain to make a determination as to whether or not it's blood. You have to touch it with the Kastle-Meyer's, the reagent.
Oh, I think most people would do that appropriately.
Okay, but if you don't, if you just pour Kastle-Meyer's on a swab and sit here and hold it in the air, and it doesn't come back positive, that's not a negative. In other words, it's not telling you there's no blood around, it's telling you didn't touch blood, correct? Do you understand my point?
No.
All right, let me ask it this way. If in fact there was testimony in this case that the blood stain or one of the blood stains was so small that the criminalist actually used a swab and attempted to get as close as he could for fear of consuming the stain onto the swab, and isn't sure he actually even touched the stain, but then pulled back out of caution to make sure that the stain was preserved for the defense.
And he got a negative Kastle-Meyer test.
Correct. That could be a false negative. correct?
That could be.
Thank you. With regard to one of the other points Mr. Plord made concerning the existence of the stain on the back of the sleeve, he used an example. I think he walked up to you and held his arm straight out and said, with the arm in this position, that you would not expect to find a blood stain. If the source of the stain was in front of my hand, you would not expect a stain to appear on the back of the sleeve, correct?
Yes.
But that depends on the position of the arm right after the gunshot, correct?
I guess the emanation of these tiny droplets, it happens in microseconds. And in fact, it happened so quickly in one case that I had that it was faster than a pistol could eject a cartridge case and put a new cartridge in the chamber.
Right.
So that gives you an example of how fast this stuff travels through the air.
The long and short of it is this portion of the jacket would simply have to be exposed, even for a millisecond, would have to be exposed to the source of the blood, correct?
At the time that you have the shooting event, I doubt that you're going to have enough movement because of the time factor in order to have blood on that part of the arm.
But that,
in the scenario that he described.
All right. And that part of the arm would simply have to be exposed to the source, even for a millisecond, correct?
Well, you're not really asking that question correctly.
Well, let me ask it this way.
It makes it difficult for me to answer it.
At some point, let's see if I can correct my own question.
Okay.
The back of the arm would have to be exposed to the source of the blood.
At the time that the blood was created and traveled through the air.
Actually, at the time that the blood had traveled far enough to get to the jacket.
That all happens within a fraction of a second.
That was my question.
Yeah.
All right.
That's 3.
All right, number 4. I'm going to take this a little bit out of order. Mr. Plord asked you about a stain on the web. We'll call it the web of Lana Clarkson's left hand.
Yes.
Did that look like high velocity impact spatter or medium velocity impact spatter?
It could be either one.
Okay. It was certainly large enough to be medium velocity, correct?
It could be either one.
And that could be from, for instance, if someone, say, had a rag and had blood on the rag and the rag snapped, that could create that medium velocity impact spatter, correct?
I don't like that analogy. A rag is a very absorptive material.
What if the blood is very wet on the rag?
Had you finished your answer?
No.
Finish your answer first.
Okay. A rag is a very absorptive material, and handling it and moving it quickly will not necessarily cause blood to be cast from it. You would have to snap it like a whip, for example, in order to get something to come off of it.
But if in fact there was enough blood on the rag, say a copious amount of blood on the rag.
Vegas to copious.
Overruled.
If there was a copious amount, you understand the word?
I understand. Go ahead.
We're on the same thing.
Yeah.
If there was a copious amount of blood on the rag, in fact, that is one possibility for medium velocity impact spatter, correct?
You would have to saturate the rag to the point that it could no longer absorb any more blood. And then it would drip from that, and it would drip just with the force of gravity unless you're swinging the rag or like I said, snapping it like a whip.
Right, but that portion of the rag would have to be fully absorbed. I'm sorry, would have to be fully saturated.
Yes.
Okay. Not the entire rag, but just a portion of the rag that was fully saturated.
When you're dealing with cloth, it's going, as long as you have an absorptive surface, it will absorb the stain.
All right.
And it will spread out.
Now, the other thing that Mr. Plord asked you about that particular stain was whether or not that's consistent, and I think he did it like this. Is it consistent with this? And he held his hands, palms straight out, arms locked in position, hands completely perpendicular to the ground.
For the record, that's exactly what Mr. Dixon did. ask Mr.
Objection, Your Honor. The editorializing is unnecessary.
That's an inappropriate comment that is stricken. He is making a comment on what you did with the witness. You can bring that up in argument or any other time. That's not an objection. So I am going to strike your comments from the record, and now you may proceed.
Thank you, Your Honor. What I just did was consistent with what Mr. Plord gave you as an example, correct?
Yes.
And you said that if, in fact, you face the hand perpendicular, I guess like as a backboard from the mouth, that would...
Perpendicular.
Say it again?
Perpendicular.
Thank you. Perpendicular to the source of blood, that would be inconsistent, correct?
Yes.
But once you start angling that hand in different ways, then you'll get that tadpole effect as long as the hand is angled in different
That's
ways,
right.
correct?
The angle, the hand, if it's like this, and the blood is emanating here, we don't know what this distance is. All we know is that the hand could be in this position.
The hand could be all the way down in the lap in that position, correct?
It depends. I'm not that familiar with the scene, and so I really can't answer that question for you, whether that would be consistent in this circumstance or not.
Okay, but certainly...
Mr. Jackson, how much longer do you have to go?
Not much. I can finish before lunch, I promise you, Mr. Spector. You'll be a little hungry, but not too much.
You haven't finished before lunch, but if you can finish in a short amount of time, you're fine.
You're right. All right.
Yeah, you're up to 5 here.
All right, here we go. With regard to the dot on the finger that Mr. Plord showed you, and I'm pointing to my right index finger just between my first knuckle and my second knuckle, that dot on the finger.
Yes.
If someone was talking about the back of the hand having a small amount of spatter on it, the back of either hand, and pointing to this area where basically my wrist joint is, that is not the same as the knuckle on the index finger, correct? I mean, we're talking about two different areas. Here is one, and here is another, correct?
They could all be part of the same pattern.
Right. I'm not saying that. I'm not asking that. I'm simply saying if you were to describe that portion of your hand, you wouldn't point to this portion of your hand, correct?
Gee, I guess not.
I guess not. And in fact, Mr. Plord asked you, is that little spot, and by the way, he asked you, and I'm going to step up here with the court's permission.
Yes.
I'm sorry. He asked you, Mr. Pex, if that looked like blood, correct?
Yes.
And he also asked you if that little red stain in the web of the hand looked like blood, correct?
Yes, I believe he put a scenario together.
Right. And you two were
indicate
talking
that was
about
blood.
it in terms of it being blood, correct?
Yes.
All right. With regard to the example that Mr. Plord gave you, and he held his hand like this, and I'm basically, Your Honor, I've got my fingers spread, and I don't know how to describe this, but the same way Mr. Plord was holding his hand, he said if you held your hand like this, that would be consistent with that spot on the finger being perpendicular to the source of blood, correct?
Yes.
Okay. Now, if I put a gun in my hand, the gun is going to be between, it's going to cover that exact area. If I'm holding the back of the grip of a gun and that gun is facing me and I'm grabbing it like a fist, that gun is going to cover like my hand is, correct? It's going to cover the exact area Mr. Plord is pointing to, isn't it?
If you're holding a gun and pointing away as you describe, like I'm pointing with my finger.
No, I'm reverse it. Mr. Plord was suggesting that the gun is facing me, and I've got my fingers wrapped around the back of the grip to stabilize it. That gun is going to be in here.
I think this states when I was saying holding the gun with two hands, not saying it was held with a grip or anything else.
He's adding certain things to his demonstration that he's making to the witness.
If
I'm holding the grip like I'm holding this thing.
I can answer your question.
Okay, please.
If you have an object that is between the hand and that area, then blood could not go around corners. That object would obtain the blood spatter, would not be present there.
All right. And one more question, I'll let you go. If in fact, and I think you talked about this the first time you were here, Mr. Plord brought this subject matter up again now. If in fact, Mr. Pax, as a bloodstain pattern analyst, you have a pattern at a scene, and that pattern, and I think you said that the absence of blood is also something that you take into consideration. Right?
Yes.
If the pattern is confined to an area, a specific area that's just, the blood just simply isn't found anywhere else other than this area, and the pattern on a person seated in this chair, for instance, is consistent with the pattern on a jacket, where would you have to put the jacket if the blood stain pattern found at the entire crime scene is confined to an area about this big, about 2 feet in diameter?
If you know with certainty that your blood spatter is within 2 feet and no further, then your jacket would have to be with that, if that is the source of the blood on the jacket.
Thank you, Mr. Pax. That's all I have, Judge. Thank you.
Mr. Court.
Two areas and a few questions, and hopefully get him moving. Mr. Pex, to know something with certainty, proper procedures and testing would have to be done of that area. Is that correct?
That's correct. I haven't done that.
And you've already talked about luminol procedures used by Mr. Renteria, and I'm not going to repeat those, but you've not changed any of your opinions in that regard, correct? Is that true? Okay. Now, with reference to the question by Mr. Jackson, is it possible for somebody to hold a gun and point it in their mouth, place it in their mouth, and hold it in such a way that this particular spec, if we could have this exhibit put back up, somebody to hold a gun where that, assume for purposes of this question that exhibit PP, that the gun is held and it's triggered, let's say with one of the thumbs, right or left, that a blood spatter such as PP could occur?
Yes, it's possible. Held by the left hand with the left thumb on the trigger.
And getting back to the other photograph with the tadpole, that would also be consistent with that orientation. The both of them would be consistent, correct?
Could be, yes.
Final area with reference to this pattern and the testing and so forth. If you test and you get negative Kastle-Meyer testing, phenolphthalein testing of some of the stains, that raises questions as to the pattern and the interpretation. Is that true?
Yes.
Your witness, nothing further.
Thank you. Any redirect?
Nothing.
Subject to recall, but hoping, I think by all parties, that there won't be any. Thank you very much for being here. You're excused at this time. Ladies and gentlemen, keep in mind the admonition will resume at 1:30 this afternoon.
Okay. The next hang on. Come on, StreamYard. Hi, guys. The next one is Dr. Michael Bodden. There is 11 parts to his testimony, divided by, I think there's going to be another witness in the middle of his testimony, and I think in class pressing. Go ahead, Sam. Dr. Bodden week. Let's make next week Dr. Bodden week. Let's stop. We will make next week Michael Bodden week. My animals are driving me crazy. Well, not Spike. He's being a good boy. And Chad is being a good girl. It's Belle now. My tech is driving me crazy. My dog is driving me crazy. I'm going to go take a nap. And we will do Michael Bodden next week. Poor guy. His wife is sick and he has to work. I hope she gets better. She does closing arguments, though, I think. So, Linda Kinney Bodden. She does closings. And she is fine, by the way. Like, as of right now, whatever she was sick with back then is better because she is fine now. She has a YouTube channel. What's it called, Judy? I forgot the name of it. Something about justice. She did some episodes on her channel about the Karen Reed trial. She's lost a lot of weight. She looks really good for her age. Okay, so we will do that next week, and I will see you guys Monday morning, and we will start. Bye, guys. Have a wonderful weekend. I'm going to try to have a good weekend and get some rest, because God knows I need it. Bye, guys.